ಎಕಡೆ ಕೇಳಿದ್ರೆ ರಿಜಿಸ್ಟರ್
ಮೋಸ್ಟ್ಲಿ ಇದೆಯಾ ಅಂತ ಕೋರ್ಟಲ್ದೇನ ಅದು
ಕೋರ್ಟಲ್ಲೇ
ಹ್ಮ್ ಹ್ಮ್
ಮೂವತ್ತಾ
Kind indulgence, my lord. I'm sorry. My lord, is a petty appellant is the senior citizen about 90 years, my lord. Land acquisition BDA matter is in the year 16. It is in the final hearing. Before the Dasara vacation, it was listed. It was not reached, my lord. My lord has directed to post the matter immediately after the Dasara vacation because of age of the petitioner of 90 years. I request, my lord, any convenient date, my lord, any convenient date.
Cannot be on Monday, it can be on some other.
Oh, please, madam, next week, any day.
Yes.
Other day. Yesterday the night is adjourned by 1.5 months. Again, custody is not given. Even the statement is not taken at least on Monday. Because every day the child is in the school time. In fact, I want to request for today.
No, if it is not being considered at the relevant time, is it not a matter for a 227 application to be filed? Is it not a matter for the court to consider in 227 instead of a habeas corpus being moved?
Monday. In fact, I want to request for today. I want the work is taken on 28th.
Can be listed on some other day. Yes. Listed on Monday. Before that.
Because not only the attendance has come to 50% now. Monday.
Mm. MFA. In an MFA. Yes.
My lords, please. My lords, it's a matter regarding KPIDFE.
Sorry?
KPIDFE, my lords,
Mm.
Karnataka Protection of Interest of
Mm.
Depositors. My application to summon the original documents from an investigating officer is dismissed, my lords. The only urgency is that the matter has been taken up on day-to-day basis, almost on day-to-day basis, because the Act mandates timely disposal within 6 months. May be taken up on Monday, my lords.
Please.
Your lordship, it may be taken up anytime on 8th, my lords.
Which one?
Serial number 38, KPID matter, my lords.
Please wait. Any mentioning? List 1, page 1, serial number 1 to 5, page 2, 6 to 40.
Have informed the other side. And for the appellant.
I'm the other side.
Can be. Yes, when do you want it? Next week or the day?
Any date may be given, my lords.
Week after. The week after.
Yes. Page 3, 15 to 22.
That serial number 22, my lords, may be taken up next week, my lords. I will inform the other side. I am for the petitioner.
Yes.
Yes.
Page 4, 23. Page 5, 24 to 28. Page 6, 29 to 33. Page 7, 34. Page 8, 35 to 40. Page 9, 41 to 44. Page 10, 45. List 2, serial number 1.
Yes.
For the petitioner. Petitioner has been produced now.
At least detenue is before the court. And
Just a moment, just a moment.
Petitioner next friend has filed this petition.
Sorry?
Petitioner next friend has filed this petition stating that she has been illegally confined to the home as she went against the wishes of the parent.
but now she says she is
Yes.
not under any confinement. She is with her parents. Initially, she was apprehensive about the marriage alliance that was brought about. Now she's happy and the marriage is also fixed. It would be wiser if she withdraws the petition.
Yes, that would be the case on the basis of submission of her. If she says so.
Please come.
Go.
In a statement,
Yes. Your name is? Chaitra. What was the reason for the filing of the petition?
Yes.
The mother also, we'd like to talk to the mother.
Yes.
ఇక్కడ పెట్టి
ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು ಮಾಡ್ಕೊಂತಾರೆ ಈಗ ಇವೇನು ಅದೇ ಮಾಡ್ಕೊಂತಾರೆ ಮಗಳನ್ನು ಮದುವೆ ಮಾಡಿ ಕೊಡ್ತೀರಿ ಏನ್ ಮಾಡ್ತಾರೆ ಆರಾಮಾಗಿ ಹೇಳಿ ಏನ್ ಮಾಡ್ತಾರೆ ಗಾಬರಿ ಆಗ್ಬಿಡ್ತಾರೆ ಹೇಳಿದ್ ನಾನು ನಿಮ್ಗೆ ಗಾಬರಿ ಆಗ್ಬಿಡ್ತಾರೆ ಆರಾಮಾಗಿ ಅವರಿಗೆ ಫೋರ್ಸ್ ಮಾಡಿ
Sure. The bill dated 7/1/2020.
Sarojamma was granted with 4 acres of land in survey number 112 on 5/6/1965.
Under the provisions. Yes. Can you not move for revocation of the probate?
Please, madam.
Can you not move for revocation of the probate?
So far, I believe it has not been issued. The order which has been passed by the court, we came to know, then we have approached this honorable court.
Do you say?
And since they are third parties,
A
my
fraud
lord,
has been played in the matter.
they are third parties to will, my lord. Then separate suit would like is.
This Sarojamma was granted with 4 acres of land in the year 1965. When it was granted, it was bearing survey number 112. In the year 1966, Hisap or Durast has been conducted by the survey settlement authorities, and they have assigned resurvey number 142 for the same. This Sarojamma, having acquired title to an extent of 4 acre, she in the year on 13/4/2005 has gifted the same in favor of her daughter Lakshmi Devamma. This Lakshmi Devamma has sold the property in the year 2013 in favor of one Vajala Mallikarjuna. This Vajala Mallikarjuna has sold the property again in 2013 in favor of 4 persons.
Yes, what do you say about section 263?
163. But I have kept the book here. Somebody has taken it.
Specific ground on which promotion grant was obtained fraudulently by making.
163, my lord.
Concealing from court. material to the
263.
case.
160?
260,
260.
revocation of the.
Yes, ma'am.
probate.
District judge power to grant probate of administration. It's 266, my lord.
363. 263.
Just a minute.
63.
263. Revocation or annulment for just cause. The grant of probate or letter of administration may be revoked or annulled for just cause. The proceedings to obtain the grant were defective in substance. The grant was obtained fraudulently by making a false suggestion or concocted, concealing the court something material to the case. The grant was obtained by means of untrue allegation of fact, essential point of law. Yes, I may be permitted, I will approach the court. I may be reserved liberty, I will approach the court.
Withdraw it and file there.
Yes, madam. Because limitation, other things comes, I am before this honorable court in time.
MFA with liberty to approach the probate court.
Within 30 days.
Weeks.
The reason,
Within 2 weeks. Yes.
And 14 is there, limitation act, and you will help you.
Anyway, this says, even if we are hearing.
Yes, madam.
Ultimately, we can only remember.
Yes, madam.
Appear for the appellants, madam.
Yes, I contribution after cancellation of registration.
Yes, madam.
That is
So
your
after
contention.
closure of business, madam. Business has been closed. Both the partners have started their own private limited companies.
When is the cancellation of registration?
18/9/2013 is the cancellation of registration date.
9?
2013, madam.
Hmm.
Actual closure of business is on 31/7/2012 itself.
Hmm.
Thereafter, they have cleared all their dues, settled the accounts and cancelled the partnership deed. Now the claim of contribution is for the period subsequent to the closure of the establishment.
Hmm.
They have claimed a contribution of 51,31,913, which I am not liable to pay because there was no establishment at that point of time. The business was not running.
What is the finding?
The finding is at paragraph 12 at ink page 28, my lord.
Hmm.
25, my lord.
Hmm.
The applicant has taken the contention as they incurred heavy loss in their business. For that, they closed the business of the firm with effect from 31/7/2012. Then they executed the cancellation of partnership deed on 18/9/2013 and written a letter to the labor inspector on 19/10/2013. If such is the case, whether they have intimated the same to the respondent corporation for closing their business with a request to discontinue the remittance of contribution. Answer is no. No scrap of papers are placed before this court for having intimated to the respondent corporation for discontinuation of the business in the name and style of Black Belt Commando Security System. It is very surprised to note that though they are fixing the date to close the business from 31/7/2012, cancellation of partnership deed is executed on 18/9/2013. It is after 1 year, 2 months of the alleged closure of the business and intimating to the Labor Department after the lapse of 1 month from the date of cancellation of partnership deed. Why there is so delay? What prevented them to execute such documents earlier to closing the business as on the date of closing their business, if at all their contentions are genuine? Here, one more point.
Yes, I am. Yes, I am. Yes.
Please, madam. Here, one more point, the court has taken serious note. Though they have incurred heavy loss in the business disclosed that they have closed their business, but as per their own admission, they have started their separate business in different name. This is very crucial, my lord. They have started their separate business in different name by changing the firm and forming the proprietorship as Black Belt Detective Private Limited and Messrs. Black Belt Commando Security and Detective Private Limited. Though the name is changed, the nature of business are one and the same. This finding is perverse, my lord. Because for the simple reason, it's a the earlier firm was a partnership firm. Now both the partners have dissolved the firm. They have started their own business. Both the business are incorporated in the provisions of the Companies Act. It's a registered companies. And they have been paying contribution in respect of their employees, in respect of the business being run subsequently to the closure of this business. And there's no dispute with regard to that. There is no finding that I was running the business at that particular point of time. That is the main crucial issue.
Para 13 may be seen for a moment, my lords,
Hmm.
page 27.
Hmm.
During the cross-examination, my lords,
Hmm.
during the cross-examination of AW1, he has admitted for having received a C18 notice sent by the respondent corporation dated 17/8/2015 and also receipt of 45A order. Both acknowledgements are marked as exhibit R1 and R2, and perusal of both the acknowledgement, it appears the name of the establishment as Mrs. Black Belt Commando Security System. If at all the firm is dissolved with effect from 31/7/2012, how they have put the seal and signature in the year 2015 and 2017 clearly indicates that the applicant has made all the tactics to avoid to make contribution by changing the name of the firm. When once it is admitted for having received notice, what prevented them to appear in person and to produce the documents, if at all they have paid the contribution regularly? On overall, going through the contention of the applicant as well as the evidence and the documents produced by the applicant, it leads to suspect that the very approach of the applicant, as they have suppressed the true facts before this court, even for having paid the contribution for any period, they have not placed any single scrap of paper before this court. Mere there is an intimation to the labor inspector does not mean that he has accorded permission for closure and the certificate issued is cancelled. Further, the applicant has relied on the judgment of the court in economic offense situation. In CC so-and-so, it was filed by the income tax department for evading the tax by the applicant firm. It is ended in acquittal. The parameter required to prove the criminal case is totally different to the present one. My lords, here they claim that they have closed the firm in the year 2012, but they don't intimate the ESI corporation at all, my lords. They should intimate us.
Registration with the Labor Department stands withdrawn, cancelled,
That is after, even when they,
2013.
please, when they stated so, my lords, the honorable court does not believe it, saying that it is created, it is, even that document is made after a year. That's what it observes.
That is the, what the court observes is that the partnership is dissolved after a year.
After a year.
Hmm.
That partnership firm was the establishment, my lords. It's about nearly 51 lakhs, my lords, of.
The names are the same, Black Belt Detective Private Limited.
Same
and
place they are
Black
running the
Belt
business.
Commando Security and Detective Private Limited.
Same place they are
Black
running the
Belt
business.
Commando
It's the
Security
same
System.
names also. Same name in the same premises
Same-
establishment it is run. my lords.
Same named will not, the question would be whether the establishment is the same and whether the establishment is existent so as to, has to be considered.
It requires consideration.
Yes.
And moreover, my lord, the seal does not bear that of the appellant in 2015 when the notice was sent.
Hmm.
The seal is that of Black Belt Commando Security Systems Private Limited. It's a private limited company because there is some
Company then.
that is a company there.
There is also a further company. This was a partnership firm.
This was a partnership firm. The partners dissolved the partnership firm. One partner started another business in the name of
This started, my lords.
Black Belt Security Private Limited.
If as a matter of fact, the establishment is not there, then the question is, what is the establishment? What was the establishment against which the proceedings can be taken? If it's not there, it has to be considered. Yes.
I also sought for stay of the impugned order.
They are not,
Yeah, amount is about 51 lakhs if stay is granted.
25% is already paid. It has to be paid as condition for the appeal. 25% is,
Before the ESI code, I think it has been
has to
deposited.
be deposited. Does
Or
it
it
not?
has been paid, I am not very
We
sure.
make order, my lords. If it is not deposited, then let them deposit some
No,
amount.
no.
It's 51
That is
lakhs.
before the ESI code. There is a provision for waiver also. I do not know whether the trial court has waived the deposit or I have deposit. I am not very sure on that.
request is-
aspect.
25% has to be deposited.
Some deposit.
My lord.
If it is
Cost
done,
has to be there.
Since the establishment itself is closed, and
Okay.
I have paid contributions in respect of different establishments. I have started subsequently, both the partners have started different business.
Where is the material to show that?
I
you
have produced IN number 1 of 2022 before this
here, my
honorable
lords.
court to show that I have paid
From when?
from September 2022, it's 2012 itself.
that's
Subsequent to the
2009.
closure, I have started another business and I have paid
2019 they
contribution in
filed
respect of my
application.
employees.
Please do.
That's 2019, they file ESI application before the honorable court, my lords. They don't produce any document. Now, when they are filing appeal, they are producing these documents, my lords.
No, if as a matter of fact, this is correct. And they're paying contributions separately, both the firms are paying contributions since
Yes, that has
2012,
been,
then it may be a case for a.
My lord,
full
at
stay.
least-
Anyway, get instructions on that. We'll list it to a date.
Please,
Yes,
some amount, my lords.
admit, no, with regard to the amount, if as a matter of fact, from 2012 onwards, they're separately paying the contributions. Then the premise that this establishment has been shut down only to evade may not be correct. We list it next month.
we
Well, please
are
get.
paying in
instructions on
respect
that.
of both the establishment
I'll take
separately.
instruction.
Yes,
I don't want
Yeah.
to make any.
yes, admit. This also, yes, sir. Please. Question of law has to be framed in a year.
Yes, yes,
Please,
yes, ma'am.
please.
Section 82, madam.
Please, my lords. Page 14.
Para 28,
Section 82
Stay of
requires.
right against prescribed in so and so and court may and if so directed by the High Court shall. Pending the decision of the appeal, withhold the payment of any sum directed to be paid by the order appealed against. Yes. What is the substantial question that you have?
in
Framed
page,
in the
in
appeal.
page 14, my lord, paragraph 28 of my appeal memorandum.
Maybe substantial question, my lords, it would be B, my lords. B and D, subject to what, my lord?
Whether the findings of ESI court that the appellant has changed its name and running similar business. So and so is perverse. If so, whether claim from contributions. C and D,
B also, my lord.
B also would be relevant. my
D
lords.
would be relevant.
B is relevant.
Yes. Yes, BCD,
Please.
yes. Should notice, I mean, admit the appeal. The substantial questions of law as framed at BCD of the appeal memorandum. Issue notice to the respondent on the substantial questions of law as framed in
Okay.
BCD of the appeal memorandum. List after month. List records to be called for. In the meanwhile, they stay of further proceedings till the next date of hearing. In operation of the
Not to initiate any coercive recovery.
the next date
proceedings.
of hearing, tell us whether these facts are correct.
Not to initiate any coercive recovery proceedings.
Sorry,
Not to initiate any recovery coercive proceedings.
further stay of
please.
further proceedings.
Please,
Stay of further proceedings pursuant to the
please, madam.
order included. Yes. Yes, but still on the question on the substantial
My lords, I take notice.
takes notice on the, yes. Only one. Yes,
Blush.
please give a list, date.
My lords, that stay, could it be said, my lords, subject to verification?
Subject to it. Only till the next date, specifically for
What
this
happens, my
purpose.
lords, if it is
If
again,
it comes before,
again it's
yes.
urgent, then
the learned
difficulty for
learned
us.
counsel seeks time to verify the facts as stated by the counsel for the appellant, especially in IA number
1 of 22.
3 of 22. One
1.
of 22. Yes,
26. Much.
Respondent. This is a appeal against the order passed by the trial court restitution of conjugal rights. That petitioner has married the petition respondent on 18/6/2009.
there is no divorce. How can there be a marriage?
In the last occasion, there's
When was the marriage according to you?
18/6/2009,
18
6/2009.
to a married man.
Married the respondent.
He's already married.
First,
Parties are
he
Hindus.
suppressed the facts and he's contacted the respondent for the marriage. After marriage, that it has came to know that he has already having a wife.
Why was the appellant, I mean, respondent directed to be present?
Yes, present.
Why?
In the last occasion, this court has directed to keep present the appellant.
What
What is the purpose?
what was the purpose? Because it was not us. It was
Purpose,
we are not aware what happened in the
because
last date.
this court has suggested to
Hmm.
compromise the case that our advocate for the appellant has agreed to settle the matter,
Hmm.
but he has not contacted so far.
The second marriage is through the legal. Where is the appellant? Who represents? Shall we pass it over?
But
Yes. He's asked. Call for, before 1:30, before 1:30. He's see whether this person is anywhere. Wonderful. Let him take the risk. There's nothing we can do. Second marriage government servant. Yes. Notice. Notice. 6.
They've already filed KVA.
I appeared for the respondent.
I'm furnishing the full paper book of all the papers. I'll file the paper book.
Let me
Board.
serve a copy of that. Please.
Yes,
Admitted call for record.
admit. So learned counsel takes notice for the respondent.
Please.
Call for records, list after the receipt of the records, yes.
Please.
6 weeks, after 6 weeks. probably.
After 6 weeks of final hearing. Purpose, if your lordship writes, then it becomes a little easier.
Purpose I can explain in the last paragraph which the trial court has justified in.
Purpose of the listing
Please,
counsel.
please.
Yes. Notice,
Lord, may I make a request? Lord, respondent is the resident of UK, Lord. May I also mail her, Lord, that I'm grateful. That may be.
the appellant is permitted to take out notice to the respondent. Additionally, by email communication as well.
I'm grateful.
Serial number 8, my lord. I am for the appellant, my lord. The appellant is challenging the order passed by the special court under KPID Act, my lord, Act, my lord. The special court has made an order of provisional order into absolute order and attached by the government, my lord. For
Just a
recovery of.
moment, counsel. Can we
Please, ma'am.
interrupt you for a moment?
Please, ma'am.
Why are you not appearing? We see
Sorry.
a blank screen,
Yeah, well,
still blank. And
Sorry,
not just
ma'am.
blank, it's dark. Please switch on your camera. You
Yes,
have to
ma'am.
appear before court.
No,
Even if it
sorry,
is-
sorry,
Yes,
my
yes,
lord, sorry, please.
Yes.
This,
Yes,
the appellant
Yes.
is challenging the order passed by the special court under KPID Act, my lord.
Hmm.
The special
There is
court,
no delay.
there is no delay, my lord. Within
Yes,
30
so-
days, we have.
IA 2 of 2024 is dismissed as withdrawn. Yes,
Please, my lord. This is the case, my lord. The petition appellant has availed the loan from the second response society, my lord, and of 35 lakhs in the year 2019 to purchase
Hmm.
apartment, my lord.
Hmm.
Thereafter, the society was closed, administrator was appointed.
Hmm.
In the 2019, the COVID period, the RBI has given moratorium period to pay the money, EMI amount, my lord.
Hmm.
Later, 2002, that administrator has not received any amount from me. And 2022, I received the police notice, COD notice to pay the money. Then I attended, the appellant has attended the proceedings before the COD. And he has submitted that we are ready to pay the EMI as per the terms and condition of the mortgage deed, my lord, loan agreement. Now they have given bank account that was not working. They were SBI refused earlier. Then they have given ICICI Bank. Then also they have refused to accept my EMI, my lord. Thereafter, my lord, I approved this book by filing writ petition to direction. I have made several attempts to pay the money, but due to the closure of the society, second response society, my lord, I am unable to pay the amount, my lord, loan amount. Then the first respondent approached the special court for getting the provisional order into absolute order of and recovery of amount of rupees 55 lakhs 23,885 and also 1,410 per day interest, my lord. This is unknown to law. This
just a moment, just a moment.
yes.
Does the government appear for the competent authority?
I
There is a panel counsel.
You have not been.
Yes, there you are. Yes, yes,
indulgence, my lord.
yes,
With my lord's permission, my lord.
yes. You have a
I'll
copy?
wait for my learned brother to complete the submissions.
Okay.
Because I do not have the copy of the appeal
Sorry,
memorandum, but I do
copy
have
has
the
been-
copy of the order. No, please, my lord. No, please, my lord. The first time the matter is coming up before your lordship, please, my lord.
Please serve a copy of the appeal memorandum,
Please, my lord.
appellant.
Please, my lord.
We'll have it the week
Tuesday.
after.
Eighth, my lord, eighth, subject to my lord's convenience, my lord.
Sorry,
Eighth, my lord, eighth, subject to my lord's convenience, eighth, my lord.
No, my lord.
8/11.
No, my lord, this is the apartment, my lord. We are living in that apartment, my lord. They are going to take a coercive step to remove from the premises, my lord. That is a big problem.
My lord, may I make a submission, my lord?
Additional
It
order.
is not my learned brother's case that he has not taken any money or that he is not in due any amount of money. His only contention is that he has been.
We can't, yes, please continue.
My lord, his only contention that he has been trying to pay the money, but that nobody has accepted it. But that has been answered, my lords, by the Honorable Special Court. Well, let it be a conditional interim order. If my learned friend, my lords, has inconvenience for 8, my lords, let him deposit 50% of the advance amount, the award amount, my lords.
What do you say?
Yes, my lord.
Appellant.
Please. Yes,
You
my
wish-
lord. Please, sir.
Yes.
Well, what I'll give a memo of calculation, my lord. Whatever is the due, my lord, let him deposit 50%, please, my lord.
No, that interest we will not, this one, my lord, this exorbitantly
due
they are
amount of
charging interest,
rupees.
my lord.
Loan due amount as stated is
Yes, my lord,
55
55 lakhs.
33,885.
Yes, my lord, in that.
50% of that.
55 lakhs, my lord.
Yes.
50% let him deposit, my lord.
Yes,
Please.
in that case, can the appeal be admitted? Can we hear
No,
it?
the date may be given, any date of my learned brother's choice. Any date of my learned brother's choice. Any date, my lords, of his choice, my lord.
Learned council, learned panel council, so also learned panel council takes notice for the respondents and seeks time to get a copy of the appeal memorandum shall be served on the learned council appearing for the respondents. List after 2 weeks.
Yes.
In the meanwhile, further proceedings in pursuance to the order impugned shall be kept in abeyance on condition that the petitioner deposits 50% of the amount ordered to be recovered from him in terms of the order impugned before this court within 4 weeks.
Within 4 weeks. Please.
Yes. Then it need not be on the
What?
8th. It can be after 2 weeks. Yes. The auto renewal mandate, FD and auto renewal mandate. It will also appeal for then too much of effort may not be there. Anyway, call for records. Yes, item 9, notice. 9, 10, 11, notice. All are-
For an interim order.
What is interim order, you sir?
Restitution of conjugal rights is ordered.
What happens if there is no stay? Yes, notice, let them come. 10 also husband's appeal. No, 10 is wife's appeal. You're in 10 restitution.
Please, in this petition, what happened? The petition was filed by the wife seeking maintenance under section 125 CRPC. After the service of notice in that petition, they has instituted the present petition. That's why I have sought for an interim order. After service of notice. It will come. It will come in the way of considering the 125 proceedings.
Yes, wife's appeal. Yes. There'll be a stay as sought for till the next date of hearing.
Much.
11, my lord, I sought for stay of the order, my lord. The husband's petition for divorce is allowed, my lord. He will remarry, my lord. Already he is having this.
Are there any children?
No children, my lord.
Yes.
My lord, remorder, otherwise he will marry.
Yes, issue notice. Serial number 11, issue notice. IA number 2 of 2024. Having heard the learned counsel for the appellant and in view of the submissions made on behalf of the appellant, there will be a stay as sought for in the next date of hearing. Yes. Husband's appeal. Notice.
13, I had got some difficulty. Can be had on Monday, my lord. Senior on
Monday may not.
Monday. Or,
Monday we have,
all right, any day can. I've informed the other side also.
can be on some other day.
Yes.
1911.
The first thing is to enroll and use the examination. And the second relief was to direct the respondent to take it as linguistic minority. However, the logic already done. Might stand.
It doesn't survive for consideration.
Thing survives.
You have to inspect them from maybe order of.
This writ petitioners file seeking the following reliefs. We notice that the substantive prayer sought for was in respect of the NEET examination conducted in
23 million.
the year 2023. And that since the admissions for the relevant year are already complete, no further orders are liable to be passed in this writ petition. The writ petition is therefore closed as having become infructuous.
In this case,
2023, again. Does anything survive? Paso.
Hearing for the appellate and the advocate.
Respondent.
One is not necessary since objections filed. For temporary injunction, statement of objection.
Temporary injunction is also granted, restraining me from marrying for the second time.
Hmm.
And now, my lord, they are seeking for interim maintenance. Earlier in the trial court, my lord, it was ordered 15,000 as an interim maintenance and up to the disposal of the suit. My lord,
The parties filed their assets and liability statements.
no, my lord, they are not filed. And
Please
and,
do it here.
and
Please do it.
And they have also, she had also filed, appellant had also filed a petition claiming permanent alimony of 75 lakhs and also, my lord, an accommodation
There are
along with
children?
restitution that is dismissed.
There are children.
No children, my lord. And from 2011, only for 2-3 days they did, and it has come on record that, my lord, she is in US and she is earning. And apart from the income, she's also has another income of $5,000 approximately. And, my lord, virtually, my lord.
Yes.
Main
Petition filed under 13(1)(a) and 3(a) and B, my lord. It is that she was not mentally correct. Now they are taking on that admission given by a person who they claim to be not mentally correct. Now there are two contradictory things that they are only putting forth. Now she was she was born in India and she is left to US, they stayed there. And it was agreed by the respondent here and also to go and settle there only after marriage.
Whose application was before the family court for divorce?
It was from the petitioner, the respondent here.
husband.
He only.
First
lived
it was
there-
from the
yes, ma'am.
petitioner.
The
Who was the
husband-
petitioner is the question.
yes, ma'am. The husband only lived there for 3 months.
Hmm.
And US, it is not easy to maintain any person, including their own children,
Hmm.
because the expenditure there are to another level. Now the husband who goes there, he is not willing to work. He does not put any effort. Because to secure a job there, before going only people would secure a job. Now you've agreed to live in US. The marriage was done on the same account. Now he lives to the US. And then he starts throwing all these tantrums to his father-in-law and mother-in-law living at their house, thinking that you are not taking care of me. Well, you don't know how to take care of the son-in-law. All the tantrums that they throw here.
Anyway, please place the assets and liability statements on record.
But that can be done. And secondly, Lordships, the very main petition itself can be disposed of if one paragraph in the cross-examination, she says that, my lord, she's not even willing to, only 2-3 days they stay together. And she's in US, he's in India. That this can be disposed of, Lordships.
If the petition is to be taken, if the entire cruelty is based on her mental stability. Now, if they if they remove the 13(3)(a) and B, then there is no cruelty at all. There's absolutely no cruelty. Then if that is not, then you cannot take her admissions because the entire petition is to be dismissed.
Yes.
My lord, even she says in her evidence, Lordship, she's not even willing to stay with them. That itself can be dismissed.
Therefore, the question of permanent alimony, if you're withdrawing that, it can be dismissed.
Lordships, sorry.
You're claiming permanent alimony.
No, she claimed permanent alimony. That itself also is dismissed by the trial court. It's in
Yes,
MC 1891 of 2020.
Please place your assets and liability statement on record. We'll consider it. It has to be considered on its merits. Yes, learned counsel appearing on either side. Are directed, the parties are directed to place assets and liability statements on record for further consideration of the matter. In the meanwhile, if there is any chance of settlement, attempt it.
Please, Lordships. In the meantime, can the records be called for, Lordships?
Yes.
Admitted. Records have not.
Probably here.
No,
Records are probably here. Once
it's not shown in the, please, ma'am.
Yes.
I'll need 4 weeks for the assets and liability.
List after 4 weeks.
Sorry, madam, with permission. Serial number 16 will not survive for consideration.
That's
Serial
not.
number-
Yes.
The reason is now they have amended the rules itself, what we are challenging.
Item number 16, it is submitted by the learned counsel appearing for the
I'll
petition
give the copy, your lordship.
that the
Rule 10 has been amended.
that
No.
the challenge raised in the writ petition does not survive for consideration on account of the fact that the rules which, the provision which was under challenge stands amended by a notification dated 13/6/2024. Right?
13/6/2020.
13/6/2024. The above view of the matter, nothing survives.
Rule
for
10 has been
consideration.
amended.
The submission is taken on record. The writ petition is closed,
Obliged.
is accordingly closed. What was the issue?
The issue is, your lordship,
In service.
in-service candidates, suppose if it does a diploma before joining, after completion of 5 years, we have to take the NEET examination, irrespective of the fact that we've taken first rank in the merit. In view of the fact that we hold the qualification of diploma, in spite of the fact that I'm eligible to take any of the subject, the rules prohibits that I supposed to take only that subject. Suppose that subject is not reserved for my specialization, that has been struck down by all other courts except the state of Karnataka. Now, after 5 years, they have amended. They have included that any of the subjects based on merit.
Yes.
Obliged.
Notice as to first step. Coming up for the first time, notice in the appeal as well as in the application, in the IES.
This connected MFA number 82 of 2024. That appeal has been prepared by the respondent.
Oh, that is already pending.
So it's already been and notice is being accepted by the appellate hearing.
List along with,
82 of 24.
yes.
For the appellant, my lord.
Notice.
My lord, there's an application for continuation of delay. There's a delay of 51 days in this particular appeal.
Yes, notice.
Kindly.
Notice, counsel.
Yes, my lord.
In
Yes,
the appeal as well as in the application.
kindly, my lord.
Appeal part of the
Notice.
27 is the delay as well as caveat has been filed by the opposite side. Respect to the
Caveat is filed.
copy served.
Yes. Issue notice and list on some other day. List it on some other day, we'll hear it. Just pending.
Execution number 213 of.
It is submitted by the learned counsel for the appellant that the copies have been served on the learned counsel appearing on caveat. List after a week. In the meanwhile, further proceedings. What is the
Mother died on 1.
Dissertation rights.
Visitation rights.
List this on some other day. Tuesday, let the council come. Without that, we cannot pass orders. We don't want to create a further confusion.
Day is the execution. Order.
Let it be listed. Let it be listed on Tuesday. In the meanwhile, we don't, without hearing the other side, we don't want to pass any.
Prayer becomes on the court and respect to submission to the standard. Execution is today. Any order can be passed by the court below.
What is to be executed?
About the custody of the.
After a court, a family court passes an order, after considering all the all the contentions, interacting with the child, we don't want to pass such an order in a haste. At least without hearing the other side, we should be fine. Tuesday. Get that, because notice he's already there. Okay. List it on Tuesday.
Please. That's okay.
Notice.
There is
38 days.
yes, there is one connected matter, my lord, which is MFA 4374 of 2024, where notice is already ordered. So husband,
Can be listed along with that.
absolutely.
Notice can also be ordered and it is listed along.
Very well. Grateful.
Yes. 4374.
Very well. 4374, my lords, of 2024.
24,
my lords.
Yes.
I'm grateful.
Yes. Ready? Pass over. Your matter, 23. Can be passed over. We are hearing you.
Yeah.
The argument was before another bench. My brother did not, but your synopsis is there.
Yes, madam.
Your written argument notes are also there. Can we hear the respondent now, or do you want to be heard again?
No, I'm ready
Can
to,
you-
because only
can you-
counter submission is there, madam. Everything, my part is over. Only
So-
counter submission is made.
But the bench was, the constitution of the bench was different then. Do you want to summarize your contentions also?
Whatever I want to say, everything has been stated in the written argument, madam. But before that, it is my humble request, madam. Last time, in the last occasion, I made disturbance to the court.
No.
Kindly apologize me, madam. Regarding the bench allocation.
Absolutely. Yes, not at all. So we'll pass over. We'll hear you on the merits of the matter. The argument notes are here. Yes. These are the facts. Yes. Yes.
I appear for respondent. Lord say, it is very, I am sorry to submit, very unfair. He has not been complying the office objection. These after a probate of 2009, 2021 decree judgment has been passed. All our brothers and sisters.
Just a moment. What is the office objection? Listed anyway. They don't come. If it's only the nomenclature which has to be changed, we'll disregard the office objections and see.
All our brothers and sisters,
Hmm.
they are expressing they have no confidence to see the result of case. Enjoying the fruits are entirely different, they are saying. That is what, because of his attitude.
You are for which respondent?
My lord, so first respondent,
Tippaya.
please, my lords. All are senior citizen, my lords.
Let's
It
see.
is family property.
Just a minute. Let us see. Or can be listed on the note date, because today we know they consider what we are. Yes,
He is getting rents more than 50,000 rupees.
we've heard.
And
the
he
learned-
enjoying entire suit property.
We have heard the learned counsel for the appearing for the respondent. There is no appearance for the petitioner. List on Wednesday. If the office objections are not complied with by then, appropriate orders will be passed,
That's
including,
kindly say, let it be dismissed. If it has not been complied, otherwise you will.
will be passed, including, yes, listed on Wednesday comes. If it is not complied with by then, we'll pass orders.
Much of it.
One last chance we are giving to comply. Oh. Yes, 6.
Six.
Because Wednesday it appears there is a different combination.
Please.
May not, this
Please,
bench is not
please.
sitting.
There's not one more request, Madam. Item, the respondents 2 to 5, when Chittappa is appearing, his
Yeah.
name has not been shown. Earlier his name showed
Please do that.
Chittappa.
Yes.
Chittappa.
Are
2 to 5. 2 to 5.
Week's time,
I appear for the appellant in this
week's
case.
time.
One week's. So obliged.
Week's time.
Your Lordship, I'm withdrawing the petition, Your Lordship. 2 seconds.
The learned counsel for the petitioner places a memo on record seeking to withdraw the petition. The memo is accepted on record. The petition is accordingly dismissed as withdrawn. Week's time. Await service.
Respondent in this case.
Therefore, service is complete.
Yes, complete.
Yes. it is
And for the
submitted.
ISR file,
Yes.
I would like to file objections short accommodation rent.
The IAs are not listed before us. It
Pardon
can
me?
be.
Pardon me?
The IAs are not listed. Item 29.
29.
Yes, learned counsel, so-and-so appears for the respondent and seeks time to place objections on record in the pending IAs. List on,
Eighth or ninth, my lord.
yes. Eight
Much-
left.
Much obliged.
Sorry,
1 week time may be granted to take steps, my lords.
yes,
Much.
week's time granted as sought for. Unclaimed. Repeat. Service of notice. Yes. Petitioner, the appellant shall be permitted to take out notice by service. In addition, the petitioner shall be permitted to take out notice by serving on the counsel who appeared in the court below, in the family court. Yes, not court below, in the family court. It is done. Yes, await service. Await service. Notice. Furnishing of. Yes. Yes, issue notice, await service. Yes, take out notice.
My lords, I appeal for the petitioners. Petition number 1, 2, 8, 10, 11, 12, and 16. Lords, I have filed application IA number 6 and 7. In this matter, my lords, first round of litigation is already over. And this matter went up to Honorable Supreme Court, and Honorable Supreme Court dismissed a college petition, 6 respondent, who is a errant college, who took admission for the academic year 22-23. 150 admissions had been taken when there was a disapproval order passed by NMC. NMC had said not to take any admission for the year 22-23. Despite that, my lords, they have gone ahead and they had taken 150 admissions. And my lords, subsequently, the matter came to light in August 2023, and the students moved this honorable court. And this honorable court, during the pendency, the NMC also approved transfer of all 150 students to other colleges, and which was also affirmed by this honorable court, and directed that all students have to be redistributed to other colleges by holding a counseling. And on 30th of September 2023, my lords, there was a counseling held. At that time, all 150 students were called for counseling, and they were allotted to different colleges. At that time, neither the colleges nor the DME, Director of Medical Education, nor the KEA told all these students who had taken management seats, that is 30 seats, and they did not even say what is the fee and all. Even though the parents went and asked the KEA, they said that it is the same what you had paid to the earlier college. That is 6
The pay that is fee that is payable in respect of the colleges to which you took admission.
Now, the relocated colleges have not been are not giving admission to these students.
So you have to pay the fee.
I have paid the fee. I am ready to pay as per that, my lords. 15 lakhs I have paid already to the earlier college.
Not the earlier college.
Now this college also.
These are recognized colleges.
Yes, yes.
Where permission and recognition are there.
Yes.
Therefore, now you must pay the fee as is payable in those colleges.
No, it is not, my lords, that is the case here. It is not my fault that the KEA and DME, Director of Medical Education, have given the admissions. Kindly see, my lords. Annexure A may kindly be seen.
Now, what are the office objections, counsel?
No office objections, my lords.
Was there
earlier, my lords, IA 6 may kindly be taken up, my lords. This honorable court, coordinate bench of this honorable court already.
Just a moment, it is coming up for orders and for rectification of the office objections. Are you ready for hearing? We don't have, today it may not be possible to
No,
take
my
this
lord,
up.
the reason is IA number 6 and 7 is filed because already the exams have passed, payment of fee and all notification is issued by RGHS, and exams will be taken up in November and December. The last date is
Hear it to be
Therefore,
some
my
other day.
lords, therefore it may be, earlier this honorable court has already directed them. Kindly
Two
coordinate.
things can be done. It can either be passed over and taken up after the other two combinations after lunch. That we can attempt.
Yes.
Because there are, if
Yes,
everybody is
yes.
ready, we can attempt
Yes,
that.
yes, my lords, because of the urgency only.
Yes, pass over. It'll be taken up after 3.
Afternoon.
After 3. Oh. You will come down. He also has another bench. So we don't know whether the
What I would say,
combination would.
what I would suggest,
Examination.
what I would suggest is, my lord, this matter is a very, very short point matter, would not take more than 10 minutes as far as I am concerned. Rest of them, I do not know.
Pass over.
No, not for this. My request is this. This matter actually can be disposed of finally. If my lord be pleased to allot half an hour on any particular day, it is my submission that it can be disposed of. Because only the tail end of the entire issue is over.
Because there are orders.
There are orders before this.
We'll-
So on any day, Monday, Tuesday, Wednesday, any day
Why
convenient,
is it coming up with the orders list?
because it's the tail end has only one ramification. They are not being given entry into the college officially. So then the university also will not be able to give them the hall ticket for the exam. So it just takes a short while to, one decision.
Is there anything listed on Tuesday 2:30? Tuesday 2:30 is anything listed? They have. Monday 2:30 is there? We won't adjourn it for the time being. What we'll do is, if as a matter of fact, we can come back after the other combinations, we'll take it up. Otherwise, we can give you a date. Because if we are giving the date, Monday, Tuesday, Wednesday may not be possible. It'll have to await. I mean, when is your examination?
My lords, the last date for payment of fee is 30th of November.
30th of November. So there is time.
With fee, with fine.
Then a date may be fixed for
Yes,
this.
then a date can be given. 9/11,
Yes.
9/11 at 2:30.
Yes, my lords.
Yes.
I'm sorry. 9th is the second Saturday. Sorry. Shall we try 6/11? 4 and 6 already.
Of six,
7?
there are too many matters.
7?
7 or 11, my lord. It doesn't matter.
11?
Second Saturday.
11. And don't say 2:30. Just list it. We'll see if it is possible before lunch, we'll take. 11
In the regular list. Not 2:30, regular.
regular. So that probably even
That if
before
we can do
2:30,
it
it may
before,
be
otherwise at 2:30. Oblige.
R6 is appearing? No, R6 is not relevant now.
They
The
are
others
appearing-
are,
They are appearing, my
the
lords.
others are appearing.
Others, we have served the copy, handsome earns and
Anyway, let's
mails
see.
also, my lords.
Please see what the
Yes,
office
ma'am.
objections are and see that
Please, my lords.
those are
Please.
dealt with. Yes. That will have to. That memo for retirement can be accepted. Council. That's all right. It's all right. We'll do it. We'll do it on the next date. Yes.
Please. Because of matter had indicated to be heard. Because where your lordship had granted an interim order, keeping one seat vacant. In sports.
I'm sorry, my letter doesn't know, my lord. I moved this matter yesterday because we are closing up the entire issue. One seat is kept vacant. But this has to be, my lord, before the last date, my lord. That's the
Yes,
reason I
either
moved the
date
matter.
has to be decided.
Yes. Now the government has to, with regard to the rule, government has filed statement of objection already. I have already filed my statement.
Can be heard now? It's only that short question.
That's the really short question.
Is there.
So, here, what is it? Same day?
It is
Same day.
there.
7/11.
State, it is there. Government statement? When was it filed?
I have filed it around 14. There.
Government statement, can you give us a? You've received government statements?
22/10/2020.
2210, just a moment, just a moment.
Hello,
Take it.
sorry. But my colleague was appearing. I was not aware, my lord. It's still kept in the file.
It's all right.
I guess. ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರುತ್ತೆ. You can serve the government. ಕೊಟ್ಟಿದ್ದಾರೆ.
Two candidates. Doomed list.
But the second set, I have a photocopy. I'll file a better copy
Yes,
today itself.
yes. Yes,
Point to only the relevant dates.
correct.
27/12/2022, I participated in the National Cycle Polo Championship. Not seriously disputed, they've been very fair, but they have not disputed some of these.
Hmm.
In 2023, I was eligible, that is also not in dispute. Therefore, not serial number 3 in the list of dates, I got myself admitted in Ayurvedic course, not in dispute.
Hmm.
From 4th minutes, respectfully, it may be a little important.
Hmm.
On 9/1/2024, they say application forms are called for.
Hmm.
Serial number 5 minutes in February of 2024, I make an application.
Hmm.
It is only thereafter, serial number 6 is the exact date minutes of which I filed,
Hmm.
which is 10/2/2024.
Hmm.
So in January, the application forms are called for. February, I make the application.
Hmm.
Serial number 7 is when the amendment notification is issued.
Hmm.
That is after the calling for the application, after I have filed my application. But before the window closes.
Hmm.
The window allowance closes subsequent.
Hmm.
The window closes in April.
Hmm.
Then what? At serial number 8 is the results
Hmm.
were declared
Hmm.
in July.
Hmm.
Serial number 9 is when, for the first time, I come to know that I am ineligible because my name finds place in the list of ineligible candidates.
Hmm.
Then what? I filed my writ petition
Hmm.
at serial number 13 on 11/9/2024.
11/9.
11/9.
Hmm.
Therefore, in short, my cases, on the date when the applications were called for and when I submitted my application, these amendments were not in place. Subsequently, the amendments were made. It is now, what's a law, I'm expected to know. But for the first time, the effect of the law was felt by me in August of 2024. In less than a month from there, I am before dishonorable. Because one of the grounds they take against me is illegal. Therefore, I wanted to place these down. Once, other is a farmer. There are no.
When is the ineligibility intimated to you?
16/8.
Hmm.
That is at serial number 10.
Hmm.
That is when the list is put up, that's when I know
Hmm.
that I am ineligible.
Hmm.
Then on 11/9, that is in less than 30 days, I am before this honorable court.
Hmm.
Now, your lordship, my lords, kindly see the rule in the background of these facts.
Yes.
The impugned rules, your lordship will please find at Annexure A, page 15.
15.
Please note, 1-5 Annexure A.
Yes.
This is only the amendment, my lords. My respectful submission is I have challenged the constitutional validity itself of these rules, but my submission would be that a fair interpretation itself would give me the result that I am looking for, and the validity may not even have to be tested. Amendment of Rule 9 in Sub-Rule 2. In Karnataka selection for candidates, etc., in Sub-Rule 9, the following shall be substituted, namely, that's where, my lords, the substituted provision begins. The following candidates shall be eligible for selection under sports category, namely, 1. Candidates who have represented the state or country and won medals or participated in sports competitions during the last 3 financial years, including the financial year in which the candidate has applied the application for CET under the sports quota shall be considered. If I may stop here, my lords, for a moment, I pass this test.
That is not the issue.
That is not the issue.
It is 2A, which is
Serial
the
number
issue.
2. Lords, my respectful submission is that although B begins with eligibility, Roman 1 is eligibility, Roman 2 is the marking methodology. Therefore, 2 cannot control 1. I have already passed the eligibility test. That would be my respectful submission. 1 prescribes in what circumstances one is entitled to a sports quota. Roman 2 prescribes the marking methodology for inter se seniority within the sports quota. If your lordship will
For
see
that,
please, ma'am.
there must be 2 best or 2 highest achievements in sports competitions during the year specified in clause 1.
Please, ma'am.
However, only 1 best or highest achievement shall be considered in a financial year.
In a financial year. Therefore, my lords, my respectful submission is, my first submission is that Roman 2 sub-rule A is marking methodology is not an eligibility criteria. Eligibility criteria is Roman 1. In that light, if your lordship will please see, my lords, Roman 2, the way it is written, the selection of candidates under sports quota shall be as follows. Does not say eligibility. Then
Following candidate shall be eligible for
Please.
selection under sports category.
that is the
namely.
larger heading.
Therefore, 1, 2 is
Please.
1 and 2 are both following.
Please, my lords. That, my lords, is hard to get by. But I am submitting, my lords, that between 1 and 2, if 2 is read as inhering both eligibility and the method of marking, then 1 will be rendered infructuous. The way to harmonize 1 and 2 would therefore be to say that 2 is the method of marking, 1 is the eligibility. Not 1 says this is the cutoff. If you have done this, you will be in the zone of reckoning.
Can it not be said?
Please.
Just thinking aloud. Can it
Please.
not be said that both 1 and 2 are eligibility?
Please.
And therefore, unless 1 and 2 are
Both met.
both satisfied,
Please, my lords.
the eligibility would not be there. We just
Lords,
thinking aloud.
I do not say that is not plausible. My respectful submission is, if both are plausible views, then your lordship will take the view that is more beneficial and which will subserve the object sought to be achieved by the legislation if both are plausible. If, my lords, the interpretation I am submitting is not plausible at all, then, my lords, I move to the constitutional challenge. I say, then it must be struck down. That prayer is there. In that light, my lords, may I just read Roman 2 one last time and then move on to the next point.
Yes.
The selection of candidates under sports quota shall be as follows. The best or 2 highest achievements in sports competitions during the years specified in clause 1 shall be taken into consideration. However, only 1 best or highest achievement shall be considered in a financial year. My lords, my respectful submission is, in the interim order that was initially granted by this honorable court, of course, my lords, that's an interim view. At para 5, the view is, there is no bar or prohibition for consideration of a candidate who has achieved in only 1 competition during the relevant year. That is how the rule was construed at the time of grant of interim relief. All I am submitting this, my lords, is to say this is a plausible view. not necessarily the only view. It is hard, my lords, to say this is the only view possible. That, to that extent, my lords, I admit. And your lordship may please see if
All this could be avoided if it is clearly stated what is intended.
Please, my lords.
If there is a little more clarity,
I bow down.
so many of these issues could have been avoided. 2 best or 2 highest achievements in sports competitions during the year specified in clause 1 shall be taken into consideration. However, only 1 best or highest achievement shall be considered in a financial year. What exactly does it mean?
The rule maker has to answer that. There are so many ifs and buts if the rule has to be followed.
If, especially in something of this nature, prospectus, it is so much better if it can be clearly stated in terms that there is only one interpretation possible. It's not as if it is all that difficult to call upon courts to decipher as to what you intended. So difficult.
In fact, my own personal complaint that legislative drafting is wanting.
My problem is on the basis of this rule, all admissions we have made. Only this, my lord, is, my lord.
We understand. Yes, what is?
And had he come, my lord, before starting of the first round, my lord, some clarity would have been there, my lord. But he waits. That's what my objection was. He waits.
I understand. Now, what is the objection filed by the state?
But delay is one of the grounds.
Not on what
But
you meant.
Also on the
What do you say?
paragraph.
Being the author, probably your you know we have to take. Paragraph
4 may be noticed. Page 2. It is submitted that the dictionary meaning of the word aggregate is as under a whole formed by combining several disparate elements, be total score of a player or team in a fixture comprising more than one game or round. C, formed or calculated by the combination of many separate unit or items. Thus, it is clear for the aggregate to be calculated, there has to be more than one element. Sports competition, in the present case, it's a continuation.
There again, where is the word aggregate here?
It's in Roman 4 in the rules. Sorry, it's in Roman D. Roman D at page 16.
Merit list shall be prepared considering the aggregate marks obtained by the candidates basis of the 2 highest achievements. There must be 2.
To that, my lords, my respectful submission is, this is being read by children or their parents. To say I am ineligible, is there one sentence here which says you should have at least participated in 2 in a positive form?
2 best or 2 highest?
2 best or highest. My respectful submission, my lords, does not exclude one performance. 2, because, my lords, the context in which 2 best or highest is put is to arrive at the marking, actual computation methodology. That if I've participated in 3, all 3 will not, A plus B plus C is not what I will get. Ultimately, the way they have applied this is to say, if, my lords, one has 50 marks, then I have played one sport for 50, one for 40, one for 30. Then the rule says I will get only 50 marks for that financial year. If in the next financial year I have played another sport, there I have played for 30, then I will get 50 plus 30. But in one financial year, if I have played 3, then A plus B plus C will not happen. Only one will be taken. Therefore, my lords, my respectful submission is the underlying theme is per year, one highest. Per year, one highest. And
2
this
best
is
or 2 highest in sports competition during the years shall be taken. However, only one best or highest achievement shall be considered in a financial year.
Therefore, my lords, that's the point. That
so in the preceding 3 years, you have only 1.
I have only 1. I am saying consider that one best. I fall in the second part of Roman 2A. This is on,
They have applied it as they understand it.
Please,
This selection.
they have applied it as they understand.
And the selection is over.
Lords, within less than 1 month, I came before this honorable court. Therefore, my lords, in that sense, there is no great delay from my end. Two, my lords, now, my lords, in terms of what they say, lords, am I expected to read subrule D and the word aggregate there to understand that it results in ineligibility? My respectful submission is that very argument indicates at best that is not the eligibility criteria at all. That is computation methodology. At the very least, that there are two plausible views of the rule. The defense put forth by the state, in my respectful submission, at least goes that far to say there is more than one possible view. Now, my lords, as to why the view that I am advancing may kindly be considered by this honorable court, I have 4 submissions to make. Lords, first, this is a vested right. The right vests in me when I play the sport, not when the rules come. My lords, at 9th or 10th standard, the rules then say, if you play one sport in any of the 3 financial years, you will get a certain marking, you will be eligible for sports category. That's when I play the sport. The moment I play the sport, the right contained or the benefit contained in the rule vests in me at that moment. Because, my lords, I have played the sport. I have done my part of the commitment.
Yes.
Once that right vests, then subsequent divesting can only happen prospectively, not retrospectively. It is, my lord, like saying in 11th standard, if you have scored 60 marks in chemistry, you will be allowed chemical engineering. In 11th, I scored 61. In 12th, before the exam maybe, they say, no, it is now 70 marks for chemistry eligibility. You may have passed the course. Not
to accept the contention of vested right
please
for an admission,
please
which is yet to be notified on account of the fact that you, well, yes,
Not the
I
reason,
understand the contention.
please notes, the reason I also submit is in the last year, I was given the benefit of the rule.
Because that was the rule.
That
It
was
is
the
the
rule.
rule that gives you the right, not the fact that you have participated or won the, it is the provision in the prospectus that gives you the right.
It's not, I bow down. Now, my lords, your lordship may consider this.
Yes, I understand the following argument.
Lords,
Yes.
it is a combination of the two which gives me the right. Because if the rule was there and I have not played a sport.
Correct.
Therefore, my lords, my second submission is it's a vested right in me, which is now sought to be taken away retrospectively. Because the date of vesting is the date on which I played the sport.
Yes.
Lords, the third submission is, my lords, I understand that 14 and 15 in the context of reservations and quotas are permissible. But once put into effect, my vested right takes a constitutional flavor and relates to 14 and 15 and not merely a rule. Because ultimately this rule is made under 14 and 15 read together. Therefore, my lords, to divest me of not just a statutory right, but a constitutional right retrospectively would be unfair.
Yes.
Lord, my fourth submission is, undeniably, this is a beneficial legislation. This is to benefit or inculcate sports among students. And ultimately, to find a pool of talent where a student playing sports can represent the nation, the state in some international forum someday. This ecosystem has been created. Lords, if the interpretation that I am canvassing is not adopted, then this seat will go to a general category student. In other words, a person who has played a sport which was an eligible sport as per the eligibility criteria in the year in which I played the sport.
There again, there is another problem.
Please,
Suppose we hold that your interpretation is acceptable.
please, my lords.
How do we know that there are others who have not been declared ineligible on the basis of the very same rule?
I will
Who had-
answer.
Who had higher marks?
Please, I bow down. I will answer that. My lords, I'll endeavor to answer that. Lords, the straight answer to that is, lords, they may have a right, but
They did not
laches,
seek it.
laches denies them the ability this year, but my lords, next year,
Yes.
if your lordship declares the law in my favor today, in the next year, they will still have the opportunity to take the benefit, so long as they fall within the 3 financial year category. Therefore, their right is not altogether deprived, but because third party rights have been created for this year, they will not be entitled to the benefit. That way, my lords, equity is done. The petitioner before my lords gets the benefit. Those who are in the same category will get the benefit in the next admission cycle because of the positive declaration of law at the hands of this honorable court. And this year, they are not being disentitled because they don't have a right, but they are being disentitled because of laches.
Yes.
Notes on beneficial interpretation. Lordship may please consider, when I played the sport, it was valid. Today, if the interpretation that I am submitting is not, even when I applied, it was valid. Today, if the interpretation I am canvassing is not considered, then it goes to a student who has not played a sport at all. And it is an undeniable fact that today people who have played 2 sports, but who have secured less marks than me, have secured admission. So the sport I have played is of some weighty consideration. I have secured 21 marks as per their ineligibility list. That will mean nothing.
Yes.
Therefore, my lords, my respectful submission is, if my interpretation advances the cause of the legislation, this interpretation is to be preferred over an interpretation which does not advance such a cause.
Yes.
What's 2 more submissions? That an interpretation which saves a legislation from the vice of unconstitutionality is to be preferred.
Of course.
Then, my lords, their interpretation, my respectful submission, is manifestly arbitrary because it under 14, because it deprives me of a benefit that culminated into a right. That right was given effect to in the previous year, and now their interpretation is by way of even provisions that are not explicit. That right which was recognized and which inhered in me is sought to be deprived. That interpretation is manifestly arbitrary. Therefore, my lords, my respectful submission is, if your lordship comes to the conclusion that having to have had played 2 sports is an essential criteria, then the rule must go. So far as it applies to students under the previous regime, so far as it applies to anybody who is in 10th standard today, it is a valid piece of rule making, because it gives them the line of sight that in these 3 years, if I don't play 2 sports, I am not going to get benefit of sports category.
I would say at best,
Please.
It would be the date of application at least, or the last date on which the application could be submitted, which would be the relevant date, not the date when you played the sport as such.
Not, I understand, my lords. Now your lordship may consider 2 concepts of legitimate expectation and promissory estoppel. Lords, they make a promise to me. I rely on the promise. I alter my situation. Instead of focusing on academics alone, I also play a sport. Are they not stopped today from saying you will now be deprived of the benefit? Here, my lords, is a case of literally changing the rules of the game after I have played the game.
Yes.
Not in all selection cases, of course, not in the case of admission of students. The date on which the applications open is the date of reckoning.
Date on which the applications close. The date on which the applications close is the date of reckoning in service law.
In service balance. not
In
here.
service parlance.
Please.
I'm only, no, I was just
Yes.
on that point. It is the date on which the application is closed. not
Close.
the-
Not here, the amendment was made before the applications close. That's a fact. my lords. These broadly, my lords, are my submissions. Now to respond to the contentions, both of them say, I have come late. Not my first submission is settled line of case law that waiver, estoppel, acquiescence will not operate against fundamental rights.
Hmm.
Therefore, the only legal concept which will prevent me from getting relief, if your lordship is with me on merits, that is the concept of laches. So far as laches is concerned, I am not today praying to upset the entire selection that has already taken place so that I can get to a more desirable institution. I am not asking for that. I am only asking that whatever is left over, where a third party has already not established a right to, I am making a request for only that seat. Therefore, laches will not come in my way. And if laches does not come in my way, the other principles, respectfully, my lords, may not prevent this honorable court from considering my petition.
Yes.
Please.
Yes.
As
What do
far
you
as
say?
I'm concerned, we have heard this rule has been acted. Rule has been acted upon. And selections were made in the first round and within the second round. After second round, my lord, remaining seats automatically get merged, my lord, they go. This
Yes.
is the right process. Now, my lord, students have taken, my lord, seats based on the rule. Well, all I mean, because of the interim order, we have kept this thing on hold. Even now, my lord, there is another petition which is filed, has come up today, claiming, my lord, the sports quota again. Is there today? So therefore, my lord, and on base of this very rule, in the document verification, or my lord, the verification by the state authority, 214 students were made ineligible.
Yes.
Therefore, my lord, if I have to counsel this, all 214, I am also called.
Yes.
Of the bank. Therefore, on that count also, my lord, if the petition is filed, my lord, before the first round starts, but things should have been in place.
Hmm.
The first round was over. Then after, yes, that is.
When was the first round
First round, after
conducted?
second
The
round,
counseling was conducted when?
Lord, serial number 12 in the list of dates. Lord, from serial number 11 onwards, the allotment begins.
16/8 is the date on which the
Eligibility list
ineligibility
comes.
list is. Then,
Thereafter, 1/9/2000
9 it's-
is where it starts. First round.
Hmm.
The first round concluded on 11/9, coinciding with the date on which I presented the writ petition. It got listed subsequently.
Hmm.
Last date of the rules.
She is already holding a seat, my lord, last year's seat.
Correct. That,
No doubt, my lord,
that,
he has
no,
taken neat again, he has come.
when these contentions are raised, we cannot answer that he has a seat in the last year. That may not be the answer. Contentions of this nature are raised, we have to answer that, which is why we are asking.
Neat eligible student.
Hmm.
Only thing is, that he doesn't fit in with the post quota rule. Other than post quota, my lord, he can participate in the counseling for general seats. Absolutely not. Post quota, when they hold it is ineligible. I cannot, my lord, make them eligible and lots. So rule is something was tried with the.
Yes. Hmm.
So, application to be put on March 2024, 15th March.
Yes.
Petition was filed only in September 2024.
The change in the eligibility criteria are all put up in the KEA website. Yes, when was the last date for apply? April.
Initially, it was 9/3, but they extended it.
Extended.
To April, April.
10/4/2024, serial number 5 list of dates.
Yes. Yes.
So candidates have now been selected, so he has allowed latches to take place. And he has waited even after the first round, waited till the first round of counseling was over, expecting that any unknowledge seat will be given. The others will be affected because he has allowed those candidates to use no fees based on the.
Where do you say this about these 214 candidates of your objections? Yes. Any reply?
Please, notes. 3-4 points of reply.
Yes.
Para 8 of the statement of objections of the
Mm.
state,
Mm.
they have actually been fair to me. They themselves say
Mm.
that if the language admits of some ambiguity,
Mm.
it must be interpreted in my favor.
Mm.
So they have taken this stance in para 8.
Mm.
Therefore, my lords, they don't say that my interpretation does not subserve the object of the legislation. That is one. Two,
Yes.
I will just point to case law, my lords. I will not read. I
Mm.
will point only to the. Plots 1 and 2 explicitly say, when I urge fundamental rights, they cannot say, except for latches, nothing else can be said against.
Yes. Yes. 1 and 2.
1 and 2.
Yes, yes, yes.
Then, because one could have perhaps not been ratio, ultimately they did not pay Mandalas, did not get relief in Olga Tellis. 2 is a reiteration of that principle. It comes from Basheshwarnath.
No.
Then, my lords, 3 and 4 on the principle that to set up latches, they have to specifically point out a person who is going to be affected by my petition. That is,
214 have been
lords,
specified.
lords, please, please, my lords. There, my respectful submission is I have not sought for relief for upsetting the selected candidates. Therefore, they are not in the reckoning at all.
Hmm.
So far as other candidates are concerned who may be placed similarly with me, the doctrine of latches applies only if they already have a right, and by granting relief to me, their right is going to be affected. In this case, they are not sitting in a seat that I am seeking to displace them. Therefore, my lords, I've relied on 2 judgments on latches to say their understanding of latches is an expectation of a right to an expectant candidate who falls in the same class as me. But Supreme Court has not understood latches like that.
Yes.
It is only when a direct effect is felt on an existing right in present time.
Yes.
Then what's 5 is save it from the vice of unconstitutionality in the list of authorities. 6 is that it is manifestly arbitrary. 8 and which one? Lords, your lordship may kindly see the judgment at serial number 6 at para 26 at page 103, my lords. About 5 lines from top.
(103 or 104?
104, no, I'm sorry. Apart from about 3 lines from top, apart from the fact that it would never have been the intention of the parliament to punish the applicants whose rights they had originally recognized and protected in the 2015 amendment for faults and inaction of its own officers. Such an interpretation inter alia would expose the amendment to challenge as being manifestly arbitrary. As noticed above, the court should resort to an interpretation which renders the provision constitutional and not otherwise. Accordingly, it can be concluded that central government having failed to take a decision within the prescribed time, the recommendation should be accepted.
Yes.
Then, my lords, my respectful submission is serial number 8 and 9. Lords, that today there has stopped long line of case law that after I have placed detrimental reliance on a promise made to me. And in this case, the promise is not just a policy, it's a statutory promise.
Yes.
Then, my lords, 12 and 13.
Yes.
Respectful submission.
Yes.
In the
Beneficial.
statement, they don't say this doesn't. That's what happens is, one sentence if I have to say, this seat will now go to a person who has the capacity to pay management fees as against a person who has toiled and played sport.
Expectation is not,
No, it is not the question of expectation. That is the only argument that holds any weight. That this last argument that you raise is the only argument that holds weight with us at this stage. But then, there again, there are persons who may have fared better, who may have better credentials in sports itself.
Please.
Who are included in the 214, we don't know.
So far as they are concerned.
If, as a matter of fact, this had been raised by anybody at any stage before the first stage, then all this we should have considered. At this stage, only because only one person has come up, we'll have to, if we are accepting it, we are giving it to that person regardless of the merit, regardless of the accomplishments in sports, would be the only answer according to us.
On facts, I have multiple submissions that I may
At
not.
this stage, we cannot.
There, the only answer what I have is that if your lordship gives me the benefit today, in the subsequent year, the others can take benefit. Therefore, your lordship would have done equity. Two, my lords, the question is there a prohibition because there are others who may have also had the benefit?
In an admission, according to us, there is. In an admission to a professional college, which is so coveted in the situation that we are in, according to us, there is.
In that
We
circumstance,
cannot say that this is only the person, since you have come up, your claim should be considered as against this. That is not the.
I understand. There, my lords, may I submit that instead of denying me relief, if this honorable court were to give me relief and keep the window open for others in the next year, would that be more just? As against keeping all of us out forever. Then, my lords, 14, 15, 16, 17.
Yes.
Are, my lords, case law on the importance of prospectus or information bulletin.
Of course.
And the object of sports quota, that is to ultimately create a talent pool for the country, to represent the country. It is this ecosystem where somebody says, okay, so long as my child is playing sport, even if child does not turn out to be very good in sports, there will be some place in regular academia. It is that assurance that allows parents to put children in sports. That is 15, 16, 17.
Serial number 11. Serial number 11.
Yes.
In the list of dates, serial number 9, I've put 3 serial numbers to demonstrate perhaps 2 things. At serial number 9 are students who have lesser marks than me in sports, but who have become eligible. That is one principle.
Correct.
At serial number 11, students who have lesser NEET ranking than me, because mine is less than 4,44,000, mine is 4,30,000, have been selected under the sports category. Serial number 20 is somebody who has lesser NEET ranking than me, lesser sports marks, but by dint of having played 2 sports, has got selection. Serial number 20. Only show, my lords, that the unfairness that they're saying will happen to other students, on the contrary, I would have been high up in the eligibility list.
Yes.
So grateful.
We are, as a matter of fact, grateful for the arguments that have been placed in such short notice.
Right.
Yes. Heard the learned counsel for the petitioner, the learned counsel appearing for the KEA, as well as learned government advocate appearing for the respondents. The facts of this writ petition are not in dispute. The petitioner was a NEET aspirant who had participated in the National Cycle Polo Championship in 2022-23 and was eligible for consideration under the sports quota, but for the amendment to the Karnataka selection of candidates for admission to government seats in professional educational institutions rules 2006, which was issued on 16/3/2024. It is submitted by the learned counsel for the petitioner that the amendment had occurred after the petitioner, the applications were called for, and the petitioner had submitted his online application on 10/2/2024. It is contended that the amendment resulted in divesting the petitioner of a vested legal and constitutional right to participate in the selection to professional institutions in government seats under the sports quota. And that as such, the divesting was clearly arbitrary and was against the vested legal rights of the petitioner. Full stop. It is further contended that since the amendment amended, amounted to divesting the applicants of a vested legal and constitutional right. It could only have been prospective in operation, and the benefit which had already accrued to the petitioner could not have been taken away. Further, it is contended that the setting apart of a quota for eligible sports persons being a beneficial piece of legislation, the benefit of any ambiguity should go to the petitioner who has challenged the provision before the court. It is also contended that the petitioner was informed of his ineligibility on the basis of the amended provision only on 16/8/2024 by the inclusion of his name in the ineligibility list, and that he had approached this court on 11/9/2024 by filing the writ petition, and that therefore there is no delay or laches on his part. It is also contended that the principles of legitimate expectation and promissory estoppel also prevent the contentions raised by the respondents in their objections being favorably taken note of by this court. With regard to the contention that there would have been other persons who were also included in the ineligibility list as per the amended provision, who may have a better claim to the seat in the sports quota than the petitioner. It is contended that none of such persons had thought it fit to challenge the provision, and that the petitioner who had challenged the provision and had been granted an interim order by this court for reservation of her seat should not at this stage be non-suited, since that would result in the seat being offered to a person who does not have any sports background, who would only have the right to claim it under the general category and possibly under the NRI or management quota. Full stop. The Learned Counsel would also place reliance on the decisions of the Apex Court on the several on the above contentions which are raised by him. The list, please give the list of the decisions. Statement of objections have been placed on record by both the KEA as well as the state government. The Learned Counsel for the KEA submits that the amendment has been carried out. Amendment was dated 16/3/2024, and that the amendment was conspicuously uploaded in the website of the KEA for the information of the students concerned. It is submitted that the admissions, the last date for submission of the application was in April 2024, which is after the date of the amendment, which had been conspicuously uploaded. It is submitted that the amended rule has been fully acted upon by the KEA, and that 214 students had been found eligible by applying the amended rule. And there would have been persons who ineligible. That is what that said. 214 persons have been found ineligible on the basis of that. Exactly is what we said. No, ineligible. Ineligible. Yes, ineligible on the basis of the rule, and there would have been persons who were better sportspersons and who had scored better in the NEET on the basis in the said 214. Full stop. It is further contended that the language of the amended rule would make it clear that there has to be two
Rules are at page 15.
just a moment. Two achievements in sports competitions during the years in question, and that the best or highest achievement in the said two or more is to be taken into consideration. Full stop. It is further contended that after the petitioner was informed of his ineligibility on account of the rule on 16/8/2024, the first round of counseling for seat allotment commenced on 1/9/2024. The second round was also completed, and the mop-up round of counseling, second round was also commenced on 11/9 and was completed on 18/9. Is that correct? Yeah. Was also completed on 18/9. Don't say 11/9. The second round of counseling was also completed on 18/9/2024. And it was only thereafter that the petitioner had approached this court, and the interim order of this court was passed on 19/9/2024. It is submitted that as of now, the mop-up round has also been completed, and one seat in the sports quota has been kept apart to one seat has been kept apart to accommodate the petitioner if he is successful in the writ petition as directed by this court. We have the state has also placed an objections on record, in which it is stated as follows: paragraph 4, paragraph 3, paragraph 4, and paragraph 3 and paragraph 4. Paragraph 3, 4, 5 of the state's objections. Yes, we have considered the contentions advanced on all sides. We notice that the amendment was dated 16/3/2024. It is admitted that the amendment had been notified by the KEA on its website before the last date for submission of the applications for the current year. The petitioner was informed of the fact that his claim for admission in the sports quota would not be considered as early as on 16/8/2024. The counseling, the first round of counseling was commenced on 1/9/2024, and the second round of counseling also stood completed on 18/9/2024. It was only at the stage of mop-up round of counseling that the petitioner approached this court. Admittedly, nearly a month, nearly a month after the petitioner was aware of the fact that his claim stood rejected by his being included in the ineligibility list.
Lord, I approached on 11/9. It was heard on 19/9.
Nearly.
Please, please.
Yes, we have stated that it was on 11/9
Please.
in the earlier paragraph. Full stop. Though the learned counsel for the petitioner contends that he being a sportsperson, he admittedly being a sportsperson, there would be no harm caused to other eligible persons also by the consideration of the legality of the rule. We are of the opinion that in view of the fact that the issue being considered is with regard to admission to government seats in professional educational institutions. The contention that since the petitioner had come before this court challenging the provision, within 20 days from being informed, within a month of being informed of his ineligibility on the basis of the offending provision, cannot by itself be a ground to hold that he would be entitled to admission in the sports quota. Dehors the fact that 213 others were found ineligible on the basis of the very same. 213 others. 214 includes the petitioner also. 213 others were found ineligible on the basis of the very same provision in the amended rules. Had the petitioner come before this court, raising his contentions immediately on being told of his ineligibility on the basis of the amended rules, the question would have been considered and the counseling could have been conducted, taking note of his contentions as well. However, since the petitioner chose not to challenge the prescription which was in his knowledge from 16/3/2024 onwards, and which affected him, which admittedly affected him adversely on 16/8/2024, only after the first 2 rounds of counseling was complete, we are of the opinion that he is not entitled to have the issue considered in this writ petition at this stage. The writ petition therefore fails. Same accordingly stands dismissed.
Great.
The question with regard to drafting, we don't want to put it in this because we don't want to delay this also. Otherwise, we'd have said something about it, but something has to be done. If it is clear, if it was clear at the first instance, probably it would have been challenged at the first instance. And probably this could all have been avoided. Absolutely. Yes.
Great.
We make it clear that we have not considered the challenge to the provision in this writ petition on account of the facts as stated above.
That was acted upon.
This should not be construed as meaning that we said that had he come earlier, it would have been worse. That is the only, we did not actually consider because of this fact. Yes.
Okay.
Appearing for the petitioner, your lordship,
Is this office objections? Yes. Yes, what is this about?
your lordship, this is pertaining to the medical students who were transferred to the other medical college on account of their previous college being removed from the list. The present college which have agreed them for the admission is Dr. B.R. Ambedkar, which is respondent number 7. This your lordship, this court had ordered to deposit the fee with R7, but R7 had sought for an acknowledgement from the state, R3, and the fees was not received.
This could be taken up along with the other matters.
Serial number 33 also, your lordship, it is directed to be listed on.
11 your lordships are posted.
Can it be?
I have here for respondent for 5 minutes. I have the copy.
I'll serve the copy.
You are the call
Rajasthan University.
for the university. Please serve a copy.
Please, your lordship. I'll
Yes, we'll list it on along with the other case. When has it been? 11.
oblige.
The name for R7.
Please show the name of the council for R7. Then serve a copy on our R4. R5.
My name not for.
Yes, please show the name of the learned counsel for the KEA.
It is.
Is it? Yes, it's shown for R4. Yes. Everybody else has copies.
I think it's.
Who's R6?
R6 is served, your lordship.
Is that college? The college from which you were?
It's not.
May not be relevant. Yes, is all right.
Very
This is-
same ground.
This is your sports quota.
Sports quota.
Yes. It was listed for instructions. Government, do you have instructions in this matter?
To mop up only.
Mop-up round is over.
Are any, yeah,
See, now but even this.
Yes.
does not- so this will get demerged a lot in the last.
So why did you come at this stage? Why didn't you come earlier? If your contention is that you are entitled to be included,
yes, ma'am.
now you are in the ineligible list. Ineligible list was published on 16/8/24. How can we consider it now? You should have come then. Last minute, this changing of that cannot be done. This is not a case where the person who comes only is eligible to be considered. That is not the case. This is an admission to government seats in professional educational institutions. We cannot consider this at this stage. Only on the ground of delay, nothing else. Last possible moment you come. 16/8 you knew that you were ineligible. What were you doing till now? As simple as that. We won't say anything else.
Same, serial number 33. The ground surgery in serial number 33.
Ground surgery and serial number 33 are not applicable here. Heard both sides. In view of the fact that the ineligibility list in the sports quota was published as early as on 16/8/2024. And this writ petition has been filed only yesterday, day before. Only on so-and-so. We are of the
Since there is a.
on 19th October 2024, we are of the opinion that the contentions raised cannot be considered at this stage, since even the mop-up round of counseling for professional admissions is now over.
There are number of seats are vacant. I could not able to
You cannot,
pursue my sports career.
you cannot apply in the sports quota. That is all. If you're eligible candidate, you can apply for the mop-up round and stray vacancy round as a general candidate. You can. Nothing stands in the way. It is made clear that the dismissal of this writ petition will not stand in the way of the petitioner participating in the stray vacancy round if he is otherwise eligible. In the general quota, if he is otherwise eligible, not in the sports quota.
General.
In the general quota, you can. Nothing stands in the way. Yes. Court fee not paid till now.
No.
You paid.
We are paid.
Yes. Welfare stamp is not.
Everything I have complained.
Okay.
ಅಲ್ಲ ಎಲ್ಲ ಮಾಡಿದೀವಿ ಅದನ್ನ ಅವರು ಇದು ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ. Everything we have complained.
Yes.
It is permitted in the.
If you are otherwise eligible, not- we
if,
won't permit.
Yes,
If you are otherwise eligible, this will not stand in the way of your participating as a general candidate, not as, there's no. sports
general
quota.
category if otherwise.
If you are otherwise eligible,
Public.
yes. What is serial number 3?
The restitution of tangible rights.
Ah.
Order possible in respect of second wife.
Ah.
Filed a restitution of conjugal rights.
Do you want to settle the matter? You are a government servant, right?
Today, the
The
petitioner.
ladies come. You are a government servant. The issue is this. She alleges a second marriage. If she can prove the second marriage, you are in trouble.
I will ask my.
Do you want to see whether it can be settled? She's here. So if you want, and the matter is to be conciliated and settled between you.
I will.
Otherwise, he's not here today.
But he came.
Please, counsel, explain the situation to him.
He's ready to get it settled.
Let
He's
let there
retired
be-
from the service.
let there be an attempt to conciliate between you itself. The councils can attempt a conciliation. Please,
will,
please talk to each other. If something can be settled and the matter can be closed, it can be. Because he is still a government servant.
No, he is retired from the service.
See whether something can be, because from what we understand, he does not completely deny. So therefore, if something can be worked out. he
Yes,
will not
I will
without-
talk with the.
Yes, please. So when should be, they need not come. If,
Yes, sir.
if it is, as a matter of fact, you can work something out, let them,
Okay.
as to how it can be, you can tell us.
I-
When
we
should
will
we
fi-
post
We
it?
will talk with each
When
other
should we
and
post it?
the
After
first
2
week.
weeks? After 2 weeks, we'll.
Yes.
post. So in the meanwhile, you can see whether there is any settlement possible. Yes. Yes, the appearance of the parties is exempted just after 2 weeks. And if it is being settled, probably you can file
The joint memo.
or join memo or maybe withdraw the
Oh,
appeal or what. No, appeal cannot be withdrawn. Join memo will have to be filed. Yes. You can do it. Mm.
One side, there are no ways are waiting for disposal. If honorable court permitted, I finish within 5 minutes my submission.
Yes.
But agreed by the order of the learner signature, I prefer a rate appeal. Rate appeal came to be admitted by its order dated on 9/6/2022. In the writ appeal, whether fresh inquiry is permissible in the absence of specific rule for the terminated employee without establishing the relation between the employer and employee, and admittedly charges are not in concern with the rule, and one charges can be existed and it can be existed 2 inquiry report and 2 termination order. Before deciding the issue on pleading and grounds and prior of the admitted writ appeal and prior of the writ petition, the counsel for the respondent, he filed an application before the Honorable Learned Single Judge. The Honorable Learned Single Judge passed the order by extending 5 months time for the inquiry by its order dated at 21/7/2022 without jurisdiction. My lord, once the order of Learned Single Judge matter has been seized by the coordinate bench, the subordinate court stay their hands away because there was no urgency. And then thereafter, 28/7/2022, the coordinate bench passed the order, inquiry may proceed and shall not pass the final order of the inquiry report. And then thereafter, the respondent has taken the undue advantage of the court order and conducted fair see inquiry and empty formalities without compliance of the procedure prescribed in the rule, and admittedly, no concrete material evidence pertaining to the charges and statement of allegation. And thereafter, even first charge itself inquiry proceeding has not been completed. Then thereafter, the counsel for the respondent unilaterally filed an application before the honorable court, then IA number 8 of 2022, sought for permission to take action on the inquiry report. Then thereafter, my lord, I filed an objection to IA number 8 of 2022, tried for reject application as it is not maintainable either in law and facts and divide of merit. It's a premature. But I challenged only order, validity of the order of the learner signature, not on the interim order on the extraneous subject of the admitted writ appeal. Then thereafter, my lord, the honorable court, accordingly bench, without providing the sought permission to make submission on IA number 2 of 2022, and not consider the statement of objection filed by the appellant on 13 to 2023, passed the order, directed the respondent take necessary steps pursuant to the inquiry. And then thereafter, passed the order that the party in person has not submitted the statement of objection to the IA number 8 of 2022. Though Honorable High Court has given the direction, and the party in person is submitted only oral submission, approved by that order. I preferred IA number 2 of 2023 and sought for recalling the order and enclosed the relevant document, that is such as copies of order sheet and copies of website and acknowledgement of the statement of objection filed by the appellant with affidavit, and deny the adverse remark. Then thereafter, my lord, before deciding the issue on IA number 2 of 2023 and regarding the recalling order, and during the pendency of the admitted writ appeal, there was no urgency for proceeding on the illegal inquiry report because I was terminated 17 years back. I was not in the service. Then thereafter, the coordinate bench, then consisting one of the honorable learned senior judge who had passed the conflicting and contradicted order, which is questionable the admitted writ appeal, had passed the order, directed the respondent to supply the inquiry report and penalty order if any. My lord, it invited 6th order of termination inquiry report without deciding the 5th order of termination inquiry report.
Yes.
Which is pending for disposal in the admitted writ appeal.
We are considering the appeal as against the 5th order of termination. We'll consider that. Please argue on that. Everything else is dependent. Yes.
And my submission, madam. Any order, either by issuing the termination order, removal order, or dismissal order, can be passed only when the employee is in the service. When the employee is not in the service, such order of termination or removal order cannot be issued unless there is a specific provision of ruling that we have. There's a relevant judgment has been quoted in the written argument, my lord. My lord, thereafter, I submitted one more application regarding the recalling order. My lord, whatever it may be, once the inquiry proceeding has been completed, either export order or non-coordination or what would be the reason, the inquiry officer has to supply the inquiry report. On production of the inquiry report, the inquiry disciplinary authority has to issue the Saukhash notice, enclosing the inquiry report, calling for the explanation of the charge sheeted employee. After submitted the explanation by the charge sheeted employee, the disciplinary authority has to consider the explanation in parallel with remark. And before any passing an order, they have to issue the final Saukhash. That is a procedure. Here there is no procedure that's clearly violated. It is automatically a violation of the principle of natural justice. My lord, you will assume that in the argument shape. If the interior order on the extraneous subject matter of the admitted writ appeal continue, then admitted writ appeal become infructuous.
We are hearing the appeal. Therefore, please confine your arguments to the appeal, and everything else will depend on the result of the appeal. It's only if your writ appeal is being rejected that the other question would arise. So please confine your argument to the appeal. You have argued on the appeal. The further issues we'll consider only if, as a matter of fact, we are rejecting your appeal. Let us hear the respondent on the appeal. We are not on anything which has happened thereafter. Only on the judgment and your contentions that you have now raised in the writ appeal.
My submission is only pleading and prayer and
Correct.
grounds of the admitted,
Correct.
appeal, not an interior matter of the exchange is subject.
Correct.
Yes, ma'am.
Yes.
Contention that since he is not in service, the inquiries cannot be.
No, please don't argue on the further aspects. Please argue on the writ appeal, on the appeal that is before us. That is what we have heard him on. Yes.
My lord, the inquiry has been conducted strictly in accordance with the service rules. All these stages, at every stage, the inquiry was conducted. He has been given sufficient opportunity to defend himself in the inquiry. Documents were sent to him. In fact, you see the response which we have filed, the documents which we sent to him by post, many times refused. Then through personal delivery also, efforts have been made to deliver the documents. And after delivering the documents, after giving him sufficient time, only the disciplinary authority going to the.
Now, please take us through the charges. What are the charges that you serve? This last inquiry, which is the subject matter of the writ petition, what are the charges?
So, page 24.
Of the appeal.
These are the charges are listed in page 24. And
Page?
these charges are listed and the findings.
Page 24.
24, 25, 26. Charge number.
Just a moment, counsel, 24, 25, 26 of what?
It's a statement of allegations to.
24, 25, 26 of what? Because the memo, appeal memo 20, yes. Please take us through the charge memo, please. Where is the charge memo?
Your lordship has taken this memo, my lord. I submitted on 17th September. What happened, my lord? Last time, my lord, after the argument with the prisoner, I would participate argument. I argued the matter almost 50% because there were two main issues. One is the charge sheet is not clear, that this and all that was there. Then I read out the impugned order. Where that
We'd like to see the charge memo. Let us go in that fashion. We are arguing, you're arguing a disciplinary inquiry matter.
And how did you inquiry matter?
Let us start with the charge memo.
Yes.
Here. Yes. Don't know. Yes. Yes, it is here. Page number?
Page number 24. Statement of allegation. This is the statement of invitations, my lord.
Show cause notice is dated 17/2/2020. Is that right?
Oh,
No, that is, yes, statement of allegations. Okay. That is the charge memo, according to you. Allegation in respect of charge one lacks ability to hold the post of assistant sales officer, underutilization of the services of sales staff on account of his inefficiency, resulting in causing indirect loss to the corporation. So, as factory showroom has failed to maintain proper control register, stock ledger, etc. during the internal audit conducted. This is the statement of allegations.
yes, madam. This irrigations, my lord, statement of allegation. This was served as the petitioner. And petitioner was told, it was content that I have not issued and all. This was served as the petitioner of my lord, and petitioner also submitted reply to this work notice. This is statement of allegations. That I produced, my lord, here that annexure, this explanation is 17 to 23, page number 17 to 23. To the statement we have submitted.
This is the statement of allegation.
Yes, ma'am. The statement of allegation was served and.
Charges are one, lacks capability to hold the post of assistant sales officer, underutilizing of services of sales staff on account of his inefficiency, resulting in causing indirect loss to the corporation. This is a charge.
No, there are 14 charges for my lord.
Correct?
Yes, ma'am.
This is the kind of charge.
Yes.
It's completely general. We are only alerting you to the fact that this charge appears to be quite general. Charge memo has to be specific. You must say what exactly he did.
My lord, this is what my lord, the honorable division bench, my lord, each charge they were explained. Your lordship, your kindly your lordship can see that input order, my lord, past pages, honorable court.
Allegation in respect of charge number 2, showing dishonesty or fraud in connection with the business of the corporation. So and so, yes, please read this. We'd like to know whether cumulatively does it amount to informing him what exactly is the charge against him. That is all that we need to know. So and so was called upon to explain regards the above irregularity. First charge is proper control register was not maintained. Posting in the stock ledger was not made in chronological order. Monthly statement of stock was not being sent in the prescribed form. He was not wearing a badge as required under the sale. So please notice the showroom was closed on 23/6/1993. It was noticed that the showroom was closed. On inquiry, it was found that so had left the showroom at 1:30 p.m. and other staff also left by 4:30 p.m. closed the showroom much before scheduled time. He was working as assistant sales officer in Devata Market showroom in 1992. It was reported that he failed to submit sales remittance and stock statement for the months of January and February 92. He was issued a memo dated 25/3/92, calling for its explanation for non-submission of the said statements. Has failed to perform his duties, acted in manner prejudicial to the interest of the corporation. Yes.
Allegation in respect of 2 showing dishonesty.
Yes.
Or fraud connected
Yes.
with the business of the property of the corporation. While testimony was working as assistant sales officer, so and so, it was reported that he along with the junior sales assistants were jointly responsible for shortage of 6 sarees of
And
plain
plain
material valued at 80,049. After detailed inquiry and considering his explanation, it was decided to recover the financial loss to the corporation from him and sales assistant in 24 installment. He also failed to maintain proper records of in this regard. Next, while so and so was working as a sales officer in Sponsorship, Ms. Channapatna showroom in 1989, it was reported that he had indulged in cheating the customer by wrong billing. On 21/9/89, he had prepared a bill for having sold a saree under Article 252A from the Channapatna showroom, bearing number 2449, wherein the original bill showed an entry of 564 and the duplicate and the triplicate copies of the same bill sold 520. By an official memorandum dated 11/10/89, he was called upon to submit the explanation of the charge. By inspecting the bill copies with the deputy manager, he was placed under the suspension and inquiry was conducted in charges. As the charges were proved, punishment of withholding of the money increment without effect was imposed on him. Next, and in 1994, when Ms. Y.N. Krishnamurthy was working as assistant sales officer in the Devata Market showroom, it was reported that article number 152, 150 of so and so, CD value of 4,103 was found to be short. A so-called notice was issued to him, and an inquiry was decided to recover that amount from him in 15 equal installments from his salary, and he was also warned to be more careful. By his above act, he has failed to protect the interests of the corporation and so and so. Next, my lord. Next. Three, why Krishnamurthy was working as assistant sales officer? Next slide.
Yes.
My lord, case number 3. While Krishnamurthy was working as assistant sales officer, since September 1918, it was reported that he had indulged in treating the customer by wrong billing. On 21/19/18, he had prepared a bill for having told the salary article so and so at the setup of the showroom of so and so for original also 564 and duplicate so 550. When officially nominated 11/10/18, he was called upon to submit the explanation. He was placed under suspension by his above acts. He failed without one incident, without permit that was imposed on him. In his above acts, he failed to protect the interests of the bank. Charge number 4. During the tenure as Y.N. officer, he failed to perform the duties and responsibility. He did not maintain proper control register, posting of stock register were not in chronological order. A monthly state statement that was not sent to the head office by prescribed form. Also failed to submit source remittance and stock remittance in time to head office. In spite of instructing him to attend the said functions promptly, he disregarded the same, thereby showing willful insubordination and disobedience of the lawful written in the art of the superiors, placed in authority over him, and though he was censured by more dated 21/98. As assistant sales officer, Devata Market showroom, India 1992, it is noticed that he failed to submit OC statements in time, for which a memo number 25/92 was issued to him. Krishnamurthy submitted the reply on 29/92 inter-alia, containing that the cashier and the accountant has to prepare monthly statement, sales statement, and OC statement on or before 3rd of every month, and EFO should submit the above statement to the head office by them, etc. Another letter dated 6/4/1992 was also issued, saying that after the sales manual, it is the duty of the ESO to send the management information to the head office on or before 3rd of every month, and calling upon him to furnish his reply within 7 days, which he has not completed. In this regard, a so-called notice that was issued and was also issued him, and issued on 29/12/1992 was also issued to him, and for non-submission of sales statement, they have the market complex. Next. Y.N. Krishnamurthy, while working as assistant sales officer at the Devata Complex Market Showroom, is filed to submit sales remittance and stock statement in January 1992. When he was asked to submit the explanation, he passed on the wave to his staff and further requested for posting one more person as cashier from accountant to prepare the sales remittance statement. Since the volume of daily sales of the showroom was not more than 1 or 2 sarees valued at 6,000, he was required to prepare the sales statement. However, he failed to do so. Next, when he was posted to KG Road, showroom wide on 2005, he has not shown any inclination to take up the responsibility. And instead, he made a representation dated 17/7/2005 requesting to retain his services in the head office. He also renewed under the transfer order, wide office dated office order dated 28/7/2005. He made another representation dated 9/8/2005 letters to MD regarding the retaining his services to head office till completion of the court order. By his above acts, he has committed an act of negligent work negligence in the performance of duty, thereby committed misconduct, which is the meaning of so and so. Next. In his representation dated 2/3/2003, when Krishnamurthy has questioned the action of the management in filling the post of a manager sales, he stated that the general manager was comparatively new and not aware of the rules of the company and was misguided by the subordinate staff. In the representation dated 24/3/2003, he also questioned the action of the management with regard to the redesignation of a senior post in the corporation and marked copies of his representation to board of directors and chairman of the corporation. By his acts, he has committed the act of subversive discipline, thereby committed the misconduct. Next, when Krishnamurti in his habit of idling, his office and leaving the place of work, gathering the staff around and discussing with them matters which have nothing to do with the office work. He is also in the habit of criticizing the management, instigating the staff to toe his line and writing letters to the government, making false allegations to the against the management. By his acts, he has committed the act of amounting the abandonment or attempt of the. Next, while Krishnamurti was working as a head office, the corporation during the 2005, he addressed dated 31/1/2005 to the Honorable Minister of Agriculture, with copies marked to Secretary Commerce and Industry, Department of Chairman, KSIC, questioning, complaining about the decision of the managing director to place the Philomena Raj, Vigilance Officer, in addition to the charge of post of manager sales. On 12/5/2005, he directly addressed the letter to the Chief Secretary, Joki, with the copies marked to the Principal Secretary and Secretary, Commerce and Industry Department, complaining about the Managing Director and other officers of the corporation. As per the rules, he was not authorized to communicate directly or indirectly any information to any other person to whom he is not authorized to communicate such information after such information that is why the customer is violating the rules. By the act, they are clear to protect the interest of the corporation and other actors in the manner to use the bank. And next 9. While Krishnamurti was working as assistant sales officer, Sunsilk Mills Chanapatna showroom during 89, he was responsible for shortage of sarees and plain material valued at 18,049 and also collected rupees 4,350 from customer by manufacturing the bill copies. During the tenure of assistant sales officer at Devara Market showroom, it was reported that a Zari saree was valued at 110325 was found to be short. All the above indicates that he committed an act resulting in the loss of the confidence and acted in a manner detrimental to the corporation. By his above acts, he has committed an act resulting in the loss of confidence and acted in a manner detrimental to the bank. Next, 7. While YN Krishnamurti was working as assistant sales officer at Factory Showroom, Mysore, an internal audit was conducted by one Mr. M.K. Nagraj, manager, internal auditor during February 1988. He was called upon to explain as regard irregularities, but letter 2/24/2088. In his explanation, he criticized Mr. Nagraja, stating that the accounts were not checked and audited properly by him. Next, he has sent a representation to various authorities alleging that the tainted vigilance officer was placed in charge of marketing officer and also representation dated 3/2/2003 in regard to addition of Sri Bhima Pass name for the post of manager sales. Next, the self-appraisal for year 92-93 of YN Krishnamurti was placed by the competent authority and he made allegations against reporting officer and reviewing the officer in his explanation dated 29/7/1983 and the rate is given by them. Next allegation. While YN Krishnamurti was working as assistant sales officer from the year 1988 to 94, he was discharged from the services while the arts dated 31/3/1994 for inefficiency and neglection of the duty. He was issued memo, spoke of notice, and censure on several occasions for failing to discharge his duties with the devotion and diligence. While he was working as an assistant sales officer, he failed to maintain control register, stock and sales remittance statements in time at the head office, in spite of the requesting to do so. He was responsible for shortage of stock, collected excess amount from customers by wrong billing during the tenure of assistant sales officer in various showrooms. His performance was rated as below average by the appraising authorities of PSIC, and a remark was also made that he is incapable of taking higher responsibility. All the above acts of YN Krishnamurti indicates his poor performance in discharge of duties directed to him. Next, when YN Krishnamurti was working as assistant sales officer in Sunsilk Chanapatna showroom, it is noticed that he has collected excess amount of rupees 4350 from a customer by manipulating the bill copies. An inquiry was found guilty of dishonesty in connection with the business of the corporation and he was punished. He was advised to be more careful and discharge his duty and also warned on several occasions. In spite of the same, it did not show any inclination to mend his ways. By his above acts, he has failed to discharge his duty with honesty, devotion, and acted in a manner prejudicial to the interest of the corporation, thereby committed the misconduct. When Krishnamurti was working as assistant sales officer and various branch offices of KSIC exhibited throughout his services negative contribution, some of which have been mentioned below. While working as assistant sales officer in the factory, showroom. My showroom is failed to maintain proper control register and failed to send the statements to the appropriate office. In spite of requesting into the research, they failed to do so, and it caused a cash to cash aspiration segment the law officer. Similarly, while he was working in the other market also, he failed to research the duty to honesty. He was want to be more careful and on several occasions, but he did not show any inclination to improve his performance by his acts of insubordination, disobedience, and so on and so forth. 14. In special motive while working as asset officer during the tenure as several petitions representation to the office of the state government and the MD complaining against the office of the corporation, thereby exhibiting hatredness towards the officer employed of the corporation. Some officers were as under. He sent a petition dated 31/1/2005 to the Honorable Minister of Agriculture and Technical Vigilance Officer, placed in charge of marketing manager with copy of the secretary and chairman. He sent petition on 3/2/22 in regard to revision of the Bima person to for the post of the manager. He sent petition on 54/2 to MD regarding the technical general manager MD. Stated the general manager and copy sent to the chairman and board of directors. Such is elevated hatred towards the author of the company. By his above action, he has committed the act of the unbecoming officer and acted in the manner of reject to the request of the bank and corporation. So these are all the charges, my lord. In these charges, that bank management produced 31 documents, examined one witness. And this inquiry was that as per the documents, the honorable court, my lord, the inquiry was commenced. But during the inquiry, the petitioners again said that I have not received the statement of imputation. And unless I it is given, I will not be able to cross the witness. And even though those inquiry officers submitted, that entire thing was given and submitted to reply. Again, the petitioner insisted, and the present officer and inquiry officer gave one more statement of objections before him against his acknowledgement. After receipt of the statement of allegations, then he crossed the witness. And the inquiry was, my lord, due to the entire, all 31 documents were marked there in the inquiry. Both petitioner was there and it was marked. Now, my lord, this after complete.
Inquiry proceedings are yes, proceeding sheet.
It is there, my lord.
Yes, yes.
Inquiry proceedings, all entire inquiry proceedings, entire here, all the details are mentioned, my lord, for convenience of the court. That everything is mentioned by that apparent explanation and copy of the apparent acknowledgement of the having served statement of allegation and copy of the inquiry proceeding, copy of the inquiry of the report at 14/22, copy of the second sort notice dated and the translated copy of the disciplinary authority order, copy of the daily order passed by the honorable court, copy of the 11 cases rules. All the details are enclosed here, my lord. Now, this, my lord, then after this petitioner participated in the inquiry and crossed the witness, and he was given full opportunity.
Just a moment, just a moment. What was the finding of the learned single judge
I think the inquiry officer, my lord.
in the writ petition?
The restriction stand to be pulled off. Declaring that the conclusion of Sri Kupeja Ramakrishna Bhatt in the charge being vague and imprecise, and the employee is not furnished with the records of the inquiry are contrary to the findings of the order of the division bench in writ number 6359 of 2017. The employer shall appoint the inquiry officer within 3 weeks from the date of the receipt of the certified copy of the order. The inquiry officer shall conclude the inquiry proceedings expeditiously and in any event, it is of 2 months from the date of this appointment. The employee shall cooperate and resist in such a conclusion. The employee shall be at liberty to file responses to the charges as required in the statement of allegations communicated to the employee on 17/2/2020, which is annexed as an error to the petition in point 7. The employee claim for monetary benefits shall be subject to the outcome of the aforesaid legal system. So disciplinary proceedings were held and opportunity was given to the petitioner to process the witness and after conclusion inquiry officer submitted the report to the of the charge. And the findings of the inquiry officer were sent to the petitioner and he has not submitted any reply to the Sodas Mati and this was the and the matter was placed to the disciplinary authority. Disciplinary authority answering the findings of the inquiry. And disciplinary authority as my lord impose the punishment
No, what happened thereafter? He did not submit his reply.
The letter sent the enforcement finance officer to the petitioner, it was not replied. And then the disciplinary authority after waiting for some time, and the disciplinary authority passed the orders, encouraged the fighting officer, well reasons order of about 10 pages, holding the prisoner, agreeing with the finance officer, holding the security, and impose appointment of criminal officer. And against that, my lord, this writ appeal was filed. And this writ appeal, your lordship, I have already put the argument to this, what are.
No, when was the writ appeal filed? Writ appeal was filed before that. Writ appeal was on 5/4/22. Inquiry was thereafter.
Yes, ma'am.
Writ appeal was on 5/4/2022. Now the documents that you have showed us shows that the inquiry was thereafter. Are we right?
No, inquiry was commenced, then writ appeal was filed.
Correct, correct. Therefore, the inquiry was
As per the
conducted.
order of single judgment, inquiry was commenced, as directed. Then if I writ appeal, I said that inquiry should not be proceeded with. Then this, that your lordship may kindly see the order passed.
Just a moment,
Page number,
just a moment.
document is number 45.
No, the proceeding sheet that you have produced shows that the inquiry was thereafter. 30/9/2022. Inquiry notice 24/9/22, fixing date of inquiry on 30/9/22. Then proceeding sheet shows 30/9/22. 14/10/22. Yes.
Lordship kindly affirm, document number 8, page number 146. 9622. My lord. Third, admitted, respondent Karnataka University Corporation Limited is the representative by 28/7/2022. See, Krishnamurthy party in person, see P.P. Muttana, consent for respondent number 1, heard on IS-3 and 4 of 2022. For the reason stated in the application, duly supported by the affidavit, say, production of annexes is the dispensed with. In the result, annexes IS-3 and 4 of 22 are allowed. Heard on IA number 5, 2022. Party in person submitted that since the time limit fixed by the learned single judge to conduct the inquiry is expired, the respondent cannot proceed with the inquiry, and therefore the operation and the effect of the order passed by the learned single judge is be stayed. On the other hand, learned counsel for the respondent number 1 submits that since certified copy of the order passed by the learned single judge was received on 4/4/2022 and the inquiry officer has been appointed on 17/4/2022. The inquiry officer had issued a notice to the appellant for his appearance in the inquiry on 27/5/2022. However, the appellant sought for adjournment of the inquiry on the ground that he has filed an appeal. After hearing the party in person and the learned counsel for respondent number 1, it is directed that the inquiry against the appellant may proceed. However, the final order in the aforesaid on inquiry cannot be passed accordingly. IA 5 is disposed. On 2010/2020, party in person present in court submits that the writ appeal is listed before this court on the fixed date of the hearing. It is also submitted by the party in person that the necessary rules are not framed. Perusal of the order of this court on 28/7/2022 clearly shows that the inquiry was going on and the party in person sought certain adjournments in the process of inquiry. Considering these facts, the coordinate bench of this court permitted the inquiry to go on and further observed that the final order in the aforesaid inquiry shall not be passed. Interim application was accordingly disposed of. Now, if the inquiry is in progress, it will be in the interest of the parties to see that the inquiry is concluded. It can safely be said that the order of continuation of the inquiry dated 28/7/22 is accepted by the party in person who was present in this court on the said day. Accordingly, the parties are directed to appraise this court as soon as the inquiry is completed and the report is submitted to the disciplinary authority. Next, number 91/23. Mr. D.P. Muttan, Lieutenant Counsel of the respondent number 1, undertaken to supply a copy of the IA number 1 to Krishnamurthy, party person, who may file objections on IA number 822 as advised, if so advised. Party person pays for an additional time of 2 weeks. Now this is important. 9/10/9/2/23. Word order dated 28/7/2022. The division bench, after hearing the party and particularly on the submission that an inquiry officer has been appointed and the inquiry officer has issued the notice to the appellant for his appearance in the inquiry, court is strict to directing that the inquiry against the appellant be proceeded. However, the final order in the aforesaid inquiry shall not be passed by filing IA 8/2022, respondent through in charge general manager submitted the inquiry report in this court and further submitted that this court may pass appropriate orders in view of the inquiry report dated 9/1/23. Following order was passed. P.V. Muttana, Lieutenant Counsel for the respondent number 1, undertakes to supply a copy of IA number 2 to Mr. Krishnamurthy, party person, who may file objections on IA number 8/22, if so advised. Party person prays for an adjournment this after 2 weeks. Though the opportunity was granted to the party person to file his objections leading to IA number 8/2022, till date no objections are filed and the party person is making only oral submission to the effect that the inquiry conducted by the inquiry officer suffers on various grounds. It is not disputed that the inquiry was conducted with the permission of this court, and the inquiry report submitted before this court by way of IA number 8/22 was the third round of inquiry. In such a situation, we cannot keep the inquiry proceedings pending for further indefinite period. Accordingly, respondent is permitted to proceeding pending for further indefinite period. Accordingly, respondent is permitted to take necessary steps pursuant to the inquiry report. Needless to say that in accordance with the provisions of the law, in view of the above, IA number 8/22 stands disposed of, and let this appeal be listed in due course. IA number 9/22 and 1/23 are also disposed of.
Yes.
After this, my lord, then this matter was placed before the Vishnu Authority, this was the past order, and the order passed at all this is also produced. That is the position so far as this is concerned. Now, before that, my lord, this
Can we continue after
court
lunch?
has Vishnu Authority, my lord, they are mentioning that they have lost the confidence and all.
Can we continue after lunch?
Yes, my lord.
There is another babysitting for both of us. Yes.
I'll take only 5 minutes. Yeah.
Yes.
Your lordship's kind leave, my lords. Serial number 12, my lords. When it was called out, I was on my legs in the other courthouse, my lords. Your lordships have issued notice, my lords. Your lordships consider hearing me on application of stay, my lords. There's an urgency in the matter, my lords.
Who appears again? No, there's no appearance. Yes.
There is a fresh matter, my lords.
Yes.
My lord,
Be listed. All the others, dates will be given. Dates will be.
when they themselves have said it ಸರ್ ವಿಡಿಯೋ ಬೇಕಲ್ಲ, ವಿಡಿಯೋ ಆಡಿಯೋ ಎರಡು ಬೇಕಲ್ಲ ಇಲ್ಲ. ಸೊ ರೋಣ್ ಇದ್ದಾರೆ, ಅವ್ರು ಬೇರೆ ಕೋರ್ಟ್ ಅವ್ರು ನೋಡ್ತಾರೆ. ಇವಾಗ ಅನು ಶಿವರಾಮನ್ ಸರ್, ಜಸ್ಟಿಸ್ ಅನು ಸರ್ ಅಂಡ್ ಹೆಗ್ಡೆ ಸರ್ ಅಲ್ಲ? ಹೌದು ಆಗಿದೆ. ಇರ್ತೀರಾ ಇಲ್ಲ? ಹಾಂ. ಹಾಂ ಸರ್ ಹೇಳಿ. ಹಾಂ ಫೋಟೋಸ್ ಹಾಂ. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಪೆಂಡಿಂಗ್ ಏನೋ ಫಸ್ಟ್ ಬರೋದು ನಮಗೆ ಫೋಟೋ ಯೂಸ್ ಮಾಡ್ಬೋದಾ ಚೆಕ್ ಮಾಡ್ಕೋ ಸೌಂಡ್. ಹಲೋ ಹಲೋ ಸರ್ ಹಲೋ ಹಲೋ ಸರ್.
ಹಲೋ, ದೊಡ್ಡ ಬೆಂಚಿಂದ ಮಾತಾಡೋದು. ಹಲೋ.
Hello? Hello? What up, sir? Hello? ಯಾವುದು ಯಾವುದು serial number 20 singles 25 25 ಇನ್ನೂ ಬಂದಿಲ್ಲ
ಸರ್ ಫಸ್ಟ್ ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ಹೆಗ್ಡೆ ಸಾಹೇಬ್ರು ಲಾಗಿನ್ ಆಗ್ತಾರೆ ಸರ್, ಆಮೇಲೆ ತಮ್ದು ಸರ್ ಎರಡು ಮ್ಯಾಟ್ರ್ ಇದೆ.
ಆಯ್ತು ಮೇಡಮ್ ಆಯ್ತು.
ಓಕೆ, ಅಲ್ಲ ಅದಕ್ಕೆ ವಿಡಿಯೋನಲ್ಲಿ ಇದ್ದೀರಾ?
ಆಯ್ತು ಮೇಡಮ್ ಆಯ್ತು, ಆಫ್ ಮಾಡ್ರಿ.
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚಿಂದ. ಹಲೋ ಹಲೋ
ಹಲೋ ಹೇಳಿ.
ಧಾರವಾಡ ಬೆಂಚಿಂದ
ಹೇಳಿ.
ಆಡಿಬಲ್ ಇದೆಯಲ್ಲ?
ಆಡಿಬಲ್ ಇದೆ, ನೀವು ಏನೋ
ವಿಡಿಯೋ ಆಫ್ ಸಾಹೇಬ್ರ ಕಡೆ
ವ್ಯೂ ಇಲ್ಲ ಅಷ್ಟೇ. ಓಕೆ ಓಕೆ,
ವಿಡಿಯೋ ಸಾಹೇಬ್ರ ಕಡೆ.
ಅದೇ ಫಸ್ಟ್ ನಿಮ್ದೇನೆ.
ಓಕೆ
ಓಕೆ, ಎರಡು ಮ್ಯಾಟ್ರು ಬಂದಿದೆ ನಿಮಗೆ ಪೇಪರ್ಸ್?
ಇವಾಗ ಜಸ್ಟ್ ಬಂದಿದೆ.
ಓಕೆ ಓಕೆ, ರೈಟ್. ಹೌದು ಸರ್. ಸ್ವಲ್ಪ ಟೈಮ್ ಆಗುತ್ತೆ. ಅಂದ್ರೆ 2 ಬೆಂಚ್ ಇದೆ. ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ಹೋಗಿ ಮುಗಿಸ್ಕೊಂಡೇ ಬಂದೀನಿ ಸರ್. ಇಲ್ಲಿ ಒಂದು 3 o'clock ಬಂದಾದ್ರೂ ಹಾಗೆ ಆಗುತ್ತೆ. ಯಾವುದೂ ಆಗಿಲ್ಲ ಇಲ್ಲ. 2 ವೀಸ್. ಹಲೋ. ನಾವು ಬಂದ್ಬಿಡ್ತಾರೆ ಟೈಮ್ ಗೊತ್ತಿಲ್ಲ ಇವಾಗ. ಹೌದಾ? ಅವ್ರು ಬಂದ್ಮೇಲೆ ನಾನು ನಿಮ್ಗೆ ಬರ್ಬೇಕಾಗುತ್ತೆ. ಓಕೆ. ಓ ಎಸ್. ಅವ್ರು ಆಗ್ಲೇ ಕೂತ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾನು ಅವ್ರಿಗೆ ವಿಡಿಯೋ ಹಾಕೊಳ್ಕೊಳ್ಳಿ ಅಂತ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಹಲೋ.
Court officer. Court officer. Court officer, serial number 44, list number 1.
sir.
Serial number 43, list number 1. ಏನಾಯ್ತು ಡೇಟ್ ಯಾವ್ದು ಹೋಗಿದ್ರು ನೋಡಿ.
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್? ಇಲ್ಲಿ 43 ಯಾವ್ದು ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ serial number
ಇವಾಗ
43.
ಬೇರೆ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದೀವಿ ಸರ್, ದಯವಿಟ್ಟು
ಬೇರೆ ಬೆಂಚ್ ಸರ್. ಕೋರ್ಟ್ ಅಲ್ಲಿ 7 ಸರ್.
ರೆಸ್ಯೂಮ್ ಹಾಕ್ತೀವಿ. ಏನ್
ಹಾ,
ಬೇಕಾದ್ರೆ
ಸರಿ,
ಹೇಳಿ.
ಹಾ.
My lords, serial number 2, my lords, request a short accommodation, my lords. Arguing counsel on his legs in another court. Request a short accommodation in the matter, my lords.
How short?
My lords, to your convenience, my lords.
Yes, just a moment, please. Just a moment, please be here.
Seal number 1. orders. Naveed Ahmad.
For the
Yes, brother, all audible?
Audible, madam.
Yes.
They filed suit for assessment against these appellants. Suit was agreed with courts, and they were dealing with 70 lakhs. Thereafter, they filed this suit was agreed. Thereafter, they filed this service, and they made me to believe that even though 70 lakhs was the total due, they agreed for 61 lakhs and made me to believe, and thereafter a compromise was entered. As per the compromise, everyone is in parents, they have not paid. Apart from that, the 61 lakhs they agreed to pay through 3 installments. One in 31/8/2024 and another installment is 1st October. They have not paid at all, except 1 month they have not paid. As such, I have filed this application for recall. My execution petition also paid.
Has this 20 lakhs of first installment as on 38 that has been paid? Not paid.
Not paid, even 1st October also not paid.
Hmm.
It's also not paid from that day.
I've got the information that someone is expired in his family. I have to get the instructions lodged.
That
The
will not,
recalling application is not,
that will not be a reason for non-payment after entering into this agreement.
please lodge. I have to get the instructions lodged. My senior is also not in station.
This has to be complied with. Please make the payment immediately.
I'll make sure that I will do it.
Yes, not to get instructions, to see that it is,
No. Please lodge.
the directions are complied with. And when was he to vacate?
31st December.
December.
Yes,
I was granted till 31st December.
this payments as agreed have to be made.
Please lodge. I'll make sure that it will be paid within.
They will not be very claim, they will be like. In fact, I have sent copies to them yesterday after I filed a memo. Every time they are doing like this.
Yes. What do you say, brother? Shall we give them some time to see that it is
But it is to be
complied
noted-
with?
It is to be noticed that on last occasion, the counsel for appellant was not present.
Yes.
I was
Why
not-
did that happen?
No, I was unaware. The copy was not served. Recalling application copy was not served.
No, I filed a memo on the Tuesday.
No, not today.
That day I
Last
saw.
time.
I sent copies on 3rd September.
No, the objection itself, the cause list itself shows that it is not served.
No, even if
I've
it is
not got
not
the copy.
served.
Now also I don't have the
It was
copy of.
specifically stated that it had been
Now also I
sent.
don't have the copy. I'm not on that.
Memo is there on Tuesday, I filed a.
Yes.
I will get.
Yes, please get a copy. See that it is not not even a case of an order of the court.
Please.
It
I
is an
understand.
agreement
I
that
apologize
you have
because
entered
I-
into, and it was only on, only because you entered into that agreement that nothing further was considered by us. So therefore you have to,
I understand your point.
Yes.
Just I'll convey to my client and see to that it will be, the payment will be made.
well, the last part of it,
Was-
well, that is the only thing that appeals.
Please, Lord.
You have to see that it is complied with. Yes,
Yes, please, madam.
so shall we give one last chance for him to see whether he complies?
Please, madam, please.
So when? Within what time will you comply and report to us?
A week's time,
1 and 2, first 2 installments must be paid.
please. Lord.
The intention is only to drag on and thereafter vacate and not to pay. rent.
Drag on as
That
well.
is the intention from the beginning.
That,
Came on.
that we'll see. Yes. We have a listing again. We haven't listed anything. Is 811 okay,
Please, madam.
brother?
Fine.
811?
Yes.
That party is here, one of the.
Just know, just know
Yes.
him. I was searching him from that time.
Yes. And just a moment, counsel. Yes,
15 days time. We will comply that old order.
list it on 8th. In the meanwhile, whatever he is able to pay, if it is one installment, pay and report.
Please.
Without payment, there's no question of giving further time. This is, I mean, what the respondent says appears to be true. Make, if 15 days for the entire amount, pay half and report on
We will
8th.
comply the old order.
Yes,
Please, Lord.
yes, list on 8th. In the meanwhile, tell us what you have done.
Yes.
What amount has been paid? Otherwise,
Please.
yes,
It will be an order. Undertaking given by.
learned counsel for the appellant submits that there has been some delay in making the payments as agreed, and that the payments will be made
Part
within-
of payment will be made within 15 days.
Not for entire.
Entire in the
Today-
sense, whatever
today-
order,
Today is the 25th.
25.
Therefore, 15 days
Please.
time will be over by the
Eight.
date we are saying. Yes, list on 8/11.
Please.
That the payment will be made before the next date of listing, list on 8/11. Failing which we'll see. They will not fail. Yes.
Hearing on IA, seal number 2, Sridhar Prabhu.
Prepare for the petitioners, my lord, in this matter. A short accommodation, my lords. Arguing counsel is other court hall, my lords. I apologize for the
His other, yes.
But appears to have been built up because the lending department has not, the penalty has not been imposed. The lending department has to communicate to the AG's office because there was a stay order, the penalty was not imposed. Regarding what is the amount to be withheld. In fact, without the penalty being imposed, the last paid draft pension has already been, provisional pension is being given based on the last paid draft, which is actually higher than what we will receive, the penalty amount is imposed. But it appears there is some.
The petition had been disposed of.
But
Petition had been dismissed. Absolutely. No, we are just saying that the petition had also been dismissed. Even thereafter, what is the excuse for not imposing the penalty and calculating at least what the further amount due would be?
In fact,
Please take appropriate steps immediately.
despite communication, communicated by email, by post, by message, and no response. In fact, the parent department which had lent the officer, the rural development, they have communicated, sent a reminder yesterday once again after I told them. Prior to that, in July 23 itself, they had asked them to provide information to the AG's office, their accountant general's office regarding the amount to be withheld from the DGR.
Shall we say that the amount shall be computed? Then probably we'll have to hear the review petitioner for that.
Issue doesn't arise in this case, but because your lordship had asked and.
Yes,
there has
correct.
been a serious lapse and
It has to be paid. I mean, it does not need,
there appears to be the RDPS, but the other departments have done their job. And there is no response despite my communication. The direction is given, but I'll once again send the letter directly to the senior officer.
we could issue a direction, taking note of the facts that are stated. We can only say that now that the proceedings are complete, at least the other amounts due must be released.
So should be that they can do it in one day if the communication is sent to them. They only need a day's time to release the amount. We held up at the RDPR department.
What do you say? Petitioner's
Lords, I
counsel.
apologize. I apologize. The respondent counsel is not audible, my lords.
He was just saying that if there is an order, your DCRG, less what has been, less the penalty can be released. You want such an order?
My lords, our prayer is seeking more than just the releasing of the DGRF amount, my lords.
Just on some other day then. Yes.
Please, my lords.
Direction may be given to the respondent, my lord, to immediately convey to the AG's office. Because despite the communication from my side and the department, concerned department,
The
they have not.
difficulty is this, they are in a review as against the punishment itself.
Punishment.
So to say at this stage that probably you don't want the, let's hear them on the merits of the review itself and then pass orders.
Please. Please.
I understand the anxiety. But then without hearing the review petitioner, if we say this as an interim order now, it may not.
After much deliberation, your lordships had found that there's
Correct.
no prima facie error committed in rendering the
Correct.
judgment.
And now,
Because new documents
now
are
additional
sought to be
documents are
produced.
sought to be produced. Well,
Without reopening the inquiry, additional evidence cannot be considered at all.
absolutely. What do you say, brother?
Please, madam. Let the counsel for the petitioner come.
Yes, without hearing the counsel, it may not be correct. And therefore, even to say that the balance amounts will be released,
Yes.
let's hear the review on its merits and
Yes.
pass orders.
Yes.
8th itself,
Yes.
or on some other day?
No, 8th is auspicious for me. I was sworn in on that day.
Okay. 8/11.
Please, grateful.
Please, my lords.
Lords, one mention, my lord. Lords had asked us to place that, since the bench had assembled, so I just.
Yes.
Lords, the 94 amendment.
Yes.
That was a rule, my lords. That was a rule.
Yes.
So the statement of objections will be available only for an act, not for a subordinate legislation, but for a rule, my lords, the procedure is it goes to the
Explanatory
cabinet.
note will be there.
There'll be it goes to the cabinet. So the cabinet note will be there on the basis of which the rule was approved.
Yes.
But 94, we are trying to trace it. So that's why,
Not
my
there.
lords, I will not able to get it, but we got some document that it is destroyed, but by Monday, my lords, I'll place it on.
If it's not there, it's all right.
But other compilation notes, the rule is already there. But
Yes.
from the state side, we can just play,
Just
hand over that compilation to the
yes,
court
that is
officer.
all,
By
that is
Monday, end of the day, my lords, I'll do that. I just
yes,
wanted.
this is that batch case.
Got it, got it, got it.
The objects and reasons, normally in the rule, there is an explanatory note which is added. If it is there, please provide it. If not,
It's
all
not there,
right.
I'll state that in the notes, please. Grateful.
Yes, Monday. That is it.
Please.
Thank you, brother.
Dharwad bench, please connect, sir.
Namaste, my lord.
Namaste, namaste.
Pronouncement of judgment, seal number 1, Manu Prabhakar Kulkarni.
Please.
It is clear that the scope of examination by this court under section 37 of the Act of 96 also cannot travel beyond the restrictions as provided in section 34. Though the learned counsel appearing for the appellant has raised several contentions with regard to appreciation of the evidence on record by the arbitral tribunal and by the commercial court, we are of the opinion that any re-examination touching upon the merits of the dispute between the parties is to be confined only to the question whether the award was liable to be set aside on the limited grounds available on a conjoined reading of sections 34 and 37. Having given our anxious consideration to the contentions raised, we find no grounds to differ from the findings of the commercial court as to the absence of perversity or patent illegality vitiating the award. With regard to sharing of the arbitral fees, we find that the first respondent has specifically agreed to arbitration as a form of dispute resolution and had participated in the arbitral proceedings. It had only expressed inability to deposit its share of fees on the grounds of financial difficulties, etc. From consideration of the contentions advanced in the order sheets of the tribunal and the materials on record, we find no merit in the contentions raised in the said appeal. The issue raised is answered in the negative. Appeals are accordingly dismissed. There will be no order as to cost. All pending IAs shall stand disposed of.
Great.
Grateful, ma'am.
Seal number 2, Prashant VJ.
Appearing for the appellant in the matter.
Yes.
Respond.
In view of the fact that the order sought to be appealed against in the present case is not an order enumerated under Order 43 of the CPC, it is clear that an appeal would not be maintainable from such order. We are fortified by the judgments in Umrah Developers, Kandla Export Corporation. The appeal is dismissed as not maintainable without prejudice to the contentions of the parties. Time spent before this court shall be disregarded for the purpose of calculating delay if any, in any subsequent proceedings.
Oblige, Your Honor.
Number 3, Mubarak Begum, yes.
Please, my lords, appearing for the respondents in the matter.
Petitioner.
The contention that there is interrelation between two agreements executed on the same day would not be sufficient for the commercial court to hold that there is a valid arbitration clause and that the dispute between the parties is arbitrable. In the factual circumstances, we are of the opinion that the finding of the commercial court that there is no specific arbitration clause between the parties in the agreement in question and that the petition under section 8 could not have been allowed cannot be found fault with. The point raised is answered in the negative. The appeal is dismissed.
Much obliged, your lordships.
Still number 4.
We are for the appellant in this matter, Your Lordship.
Paying for the respondent.
Brother,
Yes, ma'am. Appeal is allowed. Order dated 31st July 2024 passed on IA number 2 filed by the 47th Additional Civil and Session Judge Bengaluru is set aside. Registry is directed to send the copy of this order to the commercial court to proceed with the case in accordance with the and on the merits of the case. Much obliged.
Grateful, Your Lordship.
No.
is
Hearing. Hearing on IA. Still number 5, Ajesh Kumar, yes.
Till number 5.
Yes.
Behalf of the appellant. There was an order passed by my lords with regard to appointment of arbitrator and to dispose of the section 17 application by 31/10/24.
Yes.
Lords, the first date of the first hearing was on 18th, my lords. We had received the email from the arbitrator on 15th. And thereafter, my lords, 19th itself date was fixed, but unfortunately 20th and 23rd, my lords, the wedding of the claimant's son was scheduled.
Can
So
this
we
be
sought,
allowed?
now next date of hearing is fixed. Thereafter, my lords, the court heard, we were not able to participate. We had requested for oral hearing. Court has fixed it on 30th to hear all of us. So short extension, my lords, would.
My lords,
Then-
may I just place
Yes.
few
Yes.
documents on record?
Yes. Can the time be extended by a short time, maybe
My
for
lords,
the consideration?
My lords, I just placed the
30th
records and the documents. The learned arbitrator states in his email that he requires no further time. I just placed the
No,
documents.
no, that was, my lords, before there was an email by the learned, we requested, my lords, for oral hearing, stating that the court had said that since you had not participated on 19th because the claimant's wedding was on next date, their argument was heard. Then we were given liberty, my lords, to file written submissions.
This objection you have received?
We have received. Now, my lords, we have actually requested for oral hearing initially, and we have also said that we have moved this honorable court. Then an arbitrator says we have not expressed any opinion.
Just a moment.
Lords, just take my lords to document.
Just a moment.
My lords, for the benefit of.
Just a moment, please. This at page 5 is the
Observation.
document.
Please, madam. Page 5 is the observation note by the learned arbitrator on the email. sent.
Posted on 18/10/24. Case was posted on one of the learned counsel declaring in the arbitration proceedings by letter dated 15th. Copy dated 26/9 passed in appeal between the above said parties whereby the undersigned was named as arbitrator. Tribunal had on the basis of the details of the counsel would appear on behalf of the claimant and respondent in the appeal before the by an email dated 15/10/24 had addressed the learned counsel so and so representing the respondent who is said to have represented the claimant herein was a respondent before the High Court and one so and so representative by email dated and the above said had expressed about the wedding of his son, later clarified as being reference to the son of the proprietor of the claimant. This was only for a consideration of the section 17 application.
Yes, madam. Section 17.
Even according to you, everything is over on 26th. The council has no difficulty. Council does not express any
No,
difficulty.
there was one thing which I cannot actually put it out. It was like this, my lords. I'm just stating it. We don't want to make, Mr. Raghavan had appeared in this matter. Mr. Raghavan had appeared in this matter, my lords, on the day, my lords, it was disposed of. The arrangement was that he could continue, my lords, before the arbitral proceedings. Then on the.
Want him to.
No, my lords, on the previous day, we realized in the same proceedings, my lords, had appeared for Casa Grande also in the earlier round of litigation. We had not realized that, they had not realized that. So there was an issue. Then new counsel, Mr. Pavan, came on record, my lords, in the proceedings. So he asked for a date on 26th. That is then tomorrow, Saturday, he asked for a date, but arbitrator fixed it on the next day itself. But the next day itself, the wedding was there. And yesterday, my lords, was a ceremony in Mysore. Wedding was in Bangalore. The reception was in Mysore. So therefore, my lords, he requested only. Now, my lords, kindly see page 8. Now arbitrator has obliged to our request. Page 8, my lords. After my lords, the bottom, the mail that the arbitrator writes is, dear counsel, this proceeding does not depend on any further orders from any honorable court, as the time available for disposal of the pending application has not expired as yet, and this tribunal has not sought for any extension. It is only the initiative of the learned counsel for the claimant which is not directed by this tribunal. Below that, our email stating that matter is listed today. Then, my lords, next page, page number 9, we made one more request. now the reply from the arbitrator is, respected counsel, it is odd that a fervent request ought to be made to be heard in the matter when there never was any impediment
Posted it to 30th.
30th now to hear on 17.
Hmm.
31st is the last date. My lords have fixed.
Hmm.
So arbitrator 30th, now my lords, the earlier, my lords, we were refused a hearing stating that you file your written submissions and we will pass orders. For filing claim petition, tomorrow is the last date, to 26th. We are filing claim petition today. In fact, arbitrator had expressed that it is usual section 9 application, my lord, for interim measures is a different thing because it is statutory. But usually before an arbitrator, it is better to have a claim, the main petty prayer, and then the interim as well. But then they submitted that we have urgency, section 17 may be heard. But 20,
we had,
please, my lords, we are now, my lords, we are ready to go on with the matter. Now, arbitrator has fixed it on 30th now. He has granted us an opportunity. This was today's morning development, my lords. If my lords may see, it is on 25th October, 9:41, we received this email. Now, arbitrator has fixed it on 30th. Now, my lords, this was on the premise now that today matter is listed. So, in all probability, my lords, some 31st, my lords, is a festival day. 30th, it will be heard. So, it is not, since we had committed to the tribunal that we will be seeking for extension, for passing orders at least. On that day, my lords, hearing, we are committing, my lords, that we will complete the hearing. Arbitrator has permitted us to now, after some efforts. Only thing is, my lords, 31st, arbitrator is not sought for time, but now that he is also aware of the fact that the matter has come before this honorable court, he has fixed it on 30th because the times everybody had to agree for a time. So they agreed, they also wanted it on 30th. 30th is agreed for. Now 31st is the last date. So maybe another 5 days extension, my lords, for the arbitrator to pass an order, because otherwise our commitment to the arbitrator that we will request the court for extension.
He does not appear to need any time.
No, my lords,
Maybe.
No, in fact,
Till 7th.
No, please
Leave it to
7/11.
Please.
I'll leave it to my
Not for us.
If as a matter of fact, the arbitrator requires it, can pass orders within 7/11.
Please,
This is all.
because 31st, 1st, 2nd is again a festival day. I just wanted it.
What do you say, brother?
Yes, ma'am. Please.
From whatever is placed on record, it does not appear that it is the arbitrator's requirement. But anyway, we will not, as a matter of fact, no, there'll probably be no problem with it being, if the arbitrator requires, till 7/11 for passing of the orders.
Please.
Heard both sides. We've also considered the application, the affidavit filed in support thereof, and the objections placed on record by the respondents in view of the fact that the matter now stands posted before the arbitrator on 30/10/2024, and taking note of the fervent plea made on behalf of the applicant in the IA, the time provided in the order for orders to be passed on the section 17 application shall stand extended by a week. Yes, by 1 week.
1 week.
Till shall stand extended till 7/11/2024.
7/11. Grateful notes.
So if so
Yes.
required.
About that other, oh yes. Yes, brother.
Yes, ma'am.
There is that batch cases that we have here.
Yes.
Which is posted to 30th.
Yes, ma'am.
So can we send the second set of those cases along, or
Yes.
are you coming here? Because we thought on 30th the posting is on 30th.
Yes.
2:30 PM. So it can be communicated, the file second set can be communicated there? Or
If our lordship permit to come over to Bangalore, I will come here.
either way. No, but then on 30th you can come?
Yes, ma'am.
Then because it is quite a few files.
Yes, yes.
Transporting it there and then bringing it back may be a problem. If it is
I will
possible.
take permission from our.
Okay, then maybe that will be better.
Yes.
30th, 2:30 itself?
Yes, ma'am.
Physical sitting.
Yes.
Thank you so much.
Yes, ma'am.
ಕ್ಯಾನ್ಸಲ್ ರಿಲೀಸ್ ಫ್ರಮ್ ಫಾರ್ವರ್ಡ್ ಮಾಡ್ತಾರೆ ಫೋನ್ ಮಾಡಿ.
We thought we could sit and complete this.
Yes, madam. 5 minutes only. 5 minutes.
Yes.
My lord, if lords may kindly see the orders of the district court, that is page number 145 in this.
Page number
45.
of
Of this booklet, I have given. Memo dated 17 September.
yes.
45.
Yes.
The order passed by the, that well reasoned order, each charges the order.
Hmm.
Last, I note that the inquiry officer, second paragraph. I note that the inquiry officer has found, see, YN Krishnamurthy guilty of charges contained in the above charge sheet. The proved charges against the YN Krishnamurthy establishes that lack of integrity, honesty, is negligent in deciding duties and entrusted to him, and hardly any confidence can be reposed on him. Hence, the imposition of the severe punishment warranted, concurring with the findings of the inquiry officer and taking consideration the gravity of the charges proved and other factors, the following order is passed, that is removed from service. Here, my lord, so far as the charge of integrity, honesty, and negligence, entire thing has been proved by the documentary evidence and oral evidence produced before the inquiry officer. That inquiry officer finding is there. Regarding another lack of confidence, my lord, I'd like to produce one judgment of the Honorable Supreme Court. The judgment part, page number 9, para number 20, my lord. Para number 1, 2, 3. Para number 20, paragraph 1, 2, 3. Everyone there. Once the employer has lost confidence in the employee and the bona fide loss of confidence is affirmed, the order of punishment must be considered to be immune from challenge for reason that discharging of the office of trust and confidence requires absolute integrity. The necessary implication which must be engrafted on the contract of services is that the servant must undertake to serve his master with good faith and fidelity. In case of loss of confidence, reinstatement cannot be directed. Granting of such an employee the relief or reinstatement would be an act of misplaced sympathy which can find no foundation in the law of equity. And my lord, another one judgment regarding whether loss has been done because there is no loss to the institution and all, my lord. It's on the progress court, my lord, another judgment. The last part, my lord.
Yes.
This is page number 5, para number 10. None of the grounds, reasons on which the order of the punishment of removal has been interfered with the tribunal and affirmed by the High Court are germane and can be sustained. Once it is found that the delinquent officer who is serving on the post office and defrauded the extent of 69,000 and that too by way of fraudulent withdrawal in as many as 85 RD accounts and by way of non-rate of deposits on account, no sympathy on such employee is warranted. Being a public servant in the post office, the delinquent officer was holding the post of trust merely because subsequently the employee had deposited
the defrauded amount, and therefore there is no loss caused to the department, cannot be grown to take a lenient view. Lenient view, and or how show undue sympathy in favor of such an employee. What about the loss caused to the department by way of goodwill, name of the fame of the department, and its reliability among the public? By such a misconduct act on the part of the delinquent officer, the reputation of the department has been tarnished. Therefore, in the facts and circumstances, both the tribunal as well as High Court have exceeded the jurisdiction, interfering with the quantum of punishment imposed by the tribunal authority, and no substitute the same to that of a composite. Here also, my lord, because that entire this corporation is dealing with selling of silk sarees and all customers and all these things. Now, like whatever the charges are food, about 3 charges that I read, my lord. Here also the reputation of the institution is lost, because that if the customer complaint and all settings has happened means the image and the reputation of the institution. That is why, my lord. That is what, my lord. Here also that there may not be lost, because whatever the small amount, whatever the irregulars completed, back that corporation would have recovered. But only thing is the image of the institution. Therefore, my lord, in these cases that all the 14 charges evidence the petitioner has been proved beyond the doubt on the basis of the document evidence available on record, and hence it is declared that Sabbath will be dismissed.
Yes.
Right. Counsel for the respondents, he elaborated on the out of so many allegations, I would like to draw only one allegation. Certain charges are serious nature if cheating the customer and fraud in connecting the business. Let him execute at least one complaint copy of the customer for cheating to the customer. Either proof to cheating the customer, loss to the customer, or gain of the account. Any, even generous copy also let him execute. So that without the case, whatever the penalty court, honorable court are imposing against me, I'll be accepted without disputing my lord. Then thereafter, my lord, after during the pendency of the admitted writ appeal, I submitted the rejoinder with specific relevant documents for non-supplying the copies of statement of allegation. So, rejoinder has been submitted, but even I continue because I stand only on the basis of the written. But even after the lapse of 16 years, from the date of issuing the charge sheet dated 14/2/2005, and 3-time termination order set aside by the honorable court on the same charge, same allegation, nothing else. Now the respondent is admitted that the copies of statement of allegation have not been served to the appellant. But its memo, notice itself, dated on 17/2/2020, which has been elaborated and read out before this honorable court. But in order to show the material evidence, he recorded unrelated Jaras, he recorded history of unrelated Jaras copies of penalty imposed by the imposed on the findings, which is not the subject matter of the charges. And those copies have not been served. Then the notarized, notarized. Then HR consent. The appointed as HR consultant as a management. Appointed HR consultant as a management. He produced the notarized evidence, notarized affidavit, entire 14 charges. Entire 14 charges. Even those documents also have not been supplied. Relied upon documents in the affidavit, those documents also have not been supplied. And even a notary person also he has not endorsed any Xerox copies. Endorsed as a Xerox copy. And notary person also, a book number also has not mentioned on the affidavit. For that I disputed. Well, for that rejoinder, additional document has been filed. In that copies were not notarized affidavit also elaborated, produced. And also relevant copies also have been produced for not supplying the copies of statement of allegation.
Just a moment, can I, only a factual aspect with some of it, because there is so much of gap between. The statement charge sheet was, according to you, issued on 14/2/2005. Statement of allegations are dated 17/2/2020. There is no statement of allegation before that.
Here also submitted 2010 that they said.
invitation is there. There also that petition that I have not served the invitation. I have produced the invitation also. 2006, 2005, 2005 October.
14/2/2005, you say, we are accepting your contention. 14/2/2005, you say that you have served a charge sheet. That is all. Statement of allegations to the charge sheet, through those 14 charges which you have mentioned on 14/2/2005. The statement of allegations is dated 17/2/2020.
No, my lord, that is what I am telling.
Where is that earlier statement of allegations?
No, that is produced before this honorable court. There I
No,
produced.
please don't mix up the
There
two.
is not, the date was there, that was not. there is
Please,
no-
counsel, don't mix up the two. The charge sheet, you contend that it was served on 14/2/2005. The statement of allegations.
Petition,
Ah.
14/10/2005, it was served, it was.
Where?
prepared.
Where?
That contested, it was not served on him, that is what.
There, please show us where is the statement of allegations.
They themselves is admitted in the, issuing the statement.
Please. 14/2/2005 is the charge sheet. 14 charges. The charges are these: lacks capacity to hold the post, showing dishonesty, fraud, acting in a manner prejudicial to the interest of the corporation, willful insubordination, etc., etc. Then you said that is the charge sheet. This court found that is vague. So you said that we have served the statement of allegations also. That statement of allegations was served only for factual confirmation. The statement of allegations is dated 17/2/2020. It cannot be on any earlier date.
Because that inquiry officer appointed that judge was appointed as inquiry officer at that. Inquiry officer says that during the inquiry, that statement of allegations and all you are not produced.
Correct.
Then he has passed the order that you produce the statement of allegations, proceed with the inquiry.
Correct.
Then the statement of allegation, because
That is all we wanted to know. That is only dated 17. That is only dated 17/2/2020. Statement of allegation is dated 17/2/2020. Earlier, it was only charge sheet that you say that you have served on him. Are we right? We don't want to make a factual mistake.
That charge sheet was served and that statement of it was not served. That is why it was not taken into consideration.
Correct, correct. That is all we wanted to know. So statement of allegation is only dated 17/2/2020. It cannot have been served on an earlier date. That is all we wanted to know. Yes, please proceed.
I disputed. Disputed and also disputed notarized affidavit is a false affidavit. Then there are.
Who's notarized affidavit?
Then
Who's not?
appointed HR consultant has produced the notarized affidavit of entire 14 charges without witnesses, without any witnesses. To confirm the genuinity of the document, content of the document, signature of the document.
Affidavit of whom? Affidavit of whom?
Affidavit of one of the HR consultant appointed with the disciplinary authority.
What is his name?
He is produced the notarized.
What is his name?
Chandrasekhar. That copy also produced by, in that affidavit also written, clearly written. Copies are not being served. Document related upon the affidavit, those documents also not been served, clearly written on the affidavit which has been recorded in the proceeding sheet. And also the fraudly they have taken the affidavit.
Just
none of the witnesses have not been produced to make cross examination.
Just a moment. Who were the witnesses? Who were the witnesses in the inquiry? Please, can either of you tell us who were the witnesses? From the proceeding sheet, we cannot find who the witnesses were, which is why we are asking who were the witnesses. Did you examine yourself?
No, my lord, because I've written the documents regarding the request to the inquiry, because some of the documents the entire.
Please tell me who were the witnesses? Is it evident from these proceedings? Who were the witnesses? Witness.
No,
management side, my lord, Mr. Chandrasekhar.
My lord.
Witness.
Only Chandrasekhar was there.
Defense side, no.
Defense side?
No witnesses.
No witness.
No,
Chandrasekhar was the witness for the management side, nobody else. MW1. MW1 is Chandrasekhar, nobody else.
Nobody else.
Okay.
Until now, also couldn't made any cross examination, anybody, any witnesses, even couldn't name it also. Even document also, I wanted to peruse those documents regarding the content and signature of the document also for genuinity also. They are not produced, they are not showed any also.
Just a moment. Were you permitted to cross-examine Chandrasekhar?
No, because I made only cross-examination without documentary evidence, without document.
You cross-examined.
Only few words, few lines, I made a cross-examination in what way related to the documents and incident.
Okay. Yes.
Well, after when I objected the notarized affidavit, the inquiry officer, he marked some unrelated document without executing, without producing any original document to inspect, either relevant or irrelevant. And also, I disputed. When I disputed, because I say that because not to consider those documents because I have not accepted and admitted for the charges. Thereafter, there is no dispute. My appeal today clearly says that there is no evidence to supporting the charges. And the evidence or record was contrary to the charges made. Now, my submission is only restricted. I challenged on the validity of the order of the learned single judge. And I stand by only pleading grounds and prayer of the admitted writ appeal and prayer of the writ petition, not on the after admitted the writ appeal matter. The interim relief is only temporary relief till disposal of the admitted writ appeal.
Then this court had permitted, first the learned single judge permitted the
I did not have the honorable court grant permission to face the inquiry because when the termination order is pending, a fifth inquiry order is pending, only that order on questioning, only my prayer was whether the portion of the inquiry is acceptable or not. Because the inquiry officer, he recommended to the disciplinary authority to conduct a fresh inquiry. Only that jurisdiction, that the power of the authority are questioned before the honorable court, that is my prayer. Further, given the writ appeal has been disposed of. It is a reported matter. Again, remanded back to the learned single judge. Learned single judge passed the order without considering the pleading and grounds of the writ petition. He considered only outside pleading of the respondent.
Which is the earlier writ appeal 6359? Which is the earlier writ appeal?
6359.
What does that judgment say? What does that?
Termination order has been questioned.
Where is that order?
But here you are not questioning because I'm questioning only.
No, please tell us what is the judgment in writ appeal 6359 of 2017. What are the findings?
No, in the earlier it was 53029 of 2018. Even 6359 2017 also it has been disposed of. Then thereafter that order has been questioned before the filing on SLP. During the pendency of the writ appeal, they immediately without conducting inquiry, they issued the termination order. Without conducting inquiry. That order has been questioned in the writ petition number 53029 of 2018. Page number 391. Memorandum of writ appeal. 391. Well, the honorable court, with the consent of both the parties, appointed retired district judge as the inquiry officer. So conduct a fresh inquiry. There is a fifth time inquiry. Then thereafter, the order has been passed. While passing an order, the honorable learned single judge has not set aside the order of termination. Again, the same order has been disputed by the honorable another judge and directed the appellant to get the clarification from the concerned bench regarding non-setting aside the order of the termination, either good or bad. He referred the K. Karnataka judgment. Then thereafter, on the direction of the honorable court, I filed an application before the concerned bench. The concerned bench has written that the already writ petition has been disposed of. If you agreed by this order, you can prefer an appeal. Then thereafter, Even both the side were not questioned before an appeal. Even learned signature.
Counsel, which judgment are you referring to? Are you referring to, you said the writ appeal has already been disposed
No,
of.
I am questioning only for the portion of the inquiry report and inquiry conducted by the court appointed inquiry officer, nothing else.
Counsel, please tell us which is the writ appeal that you're referring to. You just told us that by a writ appeal, it has been remanded. Which is that writ appeal? 6359 of 2017 is at.
504, writ appeal number 504.
Where is that?
Kindly turn the page number 457, madam. And before that, the learned signature judge and passed an order. Based on that, I preferred an appeal. Preferred by the respondent. It is a reported matter. Kindly turn the page number 457. Four sixty, madam. Page number, operating questions. 460. Second value. Value second.
Yes.
The para number, item number 6. This court has carefully gone through the citation furnished by the respondent, that is party in person. However, in the particular facts and circumstances of the case, as proper opportunity of hearing was not given to the appellant before this court, and also keeping in view of that, no reply, no written statement and objection, slash objection was filed with the writ petition. The judgment is delivered by the single judge is deserved to be set aside. Accordingly, the writ appeal is disposed of. The order dated 27/2020 passed by the learned single judge in writ petition number 5559 of 2000 set aside. The matter was remanded back to the learned single judge to decide the matter fresh in accordance with law. The appellant is granted 15 days time from today to file the reply to the writ petition, and matter shall be decided fresh in accordance with law. Needless to state, mentioned learned single judge shall not be influenced by earlier order and shall decide the matter fresh in accordance with law. My lord, I challenge the portion of the inquiry report in writ petition number 5559 of 2020, which has been disposed of. And also granted with all other consequential benefit, and also 6% interest also granted, 1 lakh rupees penalty also imposed. It is a reported matter.
That has been set aside. That has been set aside and the matter
Then
has
there
been
are
remanded. There is no point in stating about the earlier order, because the division bench says it is needless to mention that the learned single judge shall not be influenced by his earlier order and shall decide the matter afresh in accordance with law.
Yes.
Therefore, it has to be heard.
I stand by only portion of the inquiry report. Here also, only remanded matter. I stand by only, I challenge only portion of the inquiry report matter.
Yes.
My memorandum of writ petition number, I challenged the portion that is a page number. 36, madam. In the first volume, memorandum of writ appeal. My prayer was 36 para number, 36 page number. That's prayer. Aforesaid, the appellant prays that this honorable court may please to allow this writ appeal and set aside the order dated 23/2000. Sorry, writ petition. I'm going to read the writ petition of the prayer. It's a writ appeal. 80, madam, 80 page number. My prayer in the writ petitions. The petition respected prays that the honorable court may be pleased to call for the entire record of the case and grant following the relief. Issues a writ of secretary or any other appropriate writ or partial. The proceeding, the inquiry case number KSIC/YNK/. Writ petition number 2359 of 2018, dated 4/2/2020 of the inquiry officer appointed by the Honorable High Court in writ petition number 53029 of 2018 by its order dated on 17/2/2019. Leaving, this is the post. Leaving it open to the disciplinary authority to consider whether a fresh article of charge out is framed by him, particularly the charges and strictly in accordance with Rule 26 of KSIC 1980, and take further action for initiating the disciplinary proceeding against the DO, and to proceed further to hold the inquiry against him fresh. Certified copy is produced. Then again, amended prayer. Then issue of writ of mandamus or any other appropriate writ or order directing the respondent to resend the petitioner into service and grant all the consequential relief and benefit and date of from the date of termination dated 8/3/2006 as per the direction of this honorable division bench. Writ petition number, writ appeal number 681 of 2018 dated 16/7/2012 with full back wages, continuity of service, promotion, seniority, all of the consequential benefit with 12% interest in the year, which would have not as if the order of termination was not possible. Then, A2, restrain further action on the supposed notice from Sharpie dated 14/2005. Read with inquiry officer report dated 4/2020. Consequently, direct the disciplinary to take decision on the inquiry report by justifying or finalization of the inquiry report dated 4/2020 submitted by the inquiry officer. This is my contention and as a prayer in the writ petition. Because when there is no rule for the terminated employee in the company, and also there is no existence of relation between the master and the servant, and the charges are not admittedly charges are not in concern with the role, and also fifth inquiry report and termination address which is
If the charges themselves are found to be bad in law.
Yes, exactly.
And they're quashed.
Yes.
What happens? You're deemed to have been reinstated in service.
So they are not reinstated. Till now also struggled so many times, the court also appealed to the court also. When I writ appeal is filed, within 1 week, within 15 days, immediately they issued the termination order like this. Because here also there was no urgency, because I was terminated 17 years back, there was no relation. When the writ appeal is pending, within 30 days they are terminated without supplying the order copy, without completing the first charge itself. They admitted that the charges are not, documents are not available. There is no witnesses.
Just a moment. Sit down. Please sit down, both of you. That is at page 409, second volume. Is a inquiry officer appointed by this. Much of you. 409, 397. This is the inquiry officer appointed by this. Please see the first charge. First charge was the third day. Those allegations. Inquiry had been conducted and as well. Loss was recovered. Third charge Fourth charge is willful subordination disobedience. For that also, he has been shown as I'm sure 23/4/1990. It was notice issued in 14/4/1995. Then negligence. Sixth charge, subversive of discipline and good behavior. Criticizing management, following representations. Loss of confidence, criticizing officers, poor performance, cheating customers, height of inefficiency, representations. Inquiry officer, kindness. Served on the development officer or not in accordance with and violated of rule of cases, conduct discipline appeal rules 1980. Leaving it open to the disciplinary authority to consider whether fresh articles of charge have to be framed, particularizing charges by and strictly in accordance, and to take further action for initiating disciplinary proceeding against a DO and to proceed to file an inquiry against him afresh. The entire files. He challenges this is what having found that allegedly certain proposing this could not have been done because after all these years it is it is in 2020 that this problem then it is now the level judge says it is after level judge finds the that the charges were vague. Thereafter, this is the problem. In the earlier round, the division bench had found categorically that the charges against the employee cannot be held to be either vague or unclear or without any support. The division bench findings with reference to certain specific charges in the show cause notice from Shabbat mandate 14/2/2005. What is the problem? 6-3, writ appeal 6359 found that the charges were not vague. Also found the employee never contended that he was not issued with necessary documents. Division bench on examination had also concluded that so and so. What happened to that division bench judgment? That was taken to the apex court. 6359 you.
6359 again the even learner second. Learner single judge has been passed an order and also imposed a cost and order for the back wages. Then thereafter again the respondent has challenged before the division bench the writ appeal number 6359 of 2000.
What happened to that? You
Then
took it up in
partly allowed in remaining partly conduct directed to the respondent to conduct an inquiry and time frame. Because of that, I went to the Supreme Court.
Then what happened?
During the pendency of the Supreme Court, after obtaining the SLP number, I communicated to him not to proceed on further till disposal of the SLP. As soon as
just a moment. What happened to the SLP?
SLP has been disposed when they again issued the termination order.
That is the problem. We understand what you're stating, but that finding in writ appeal 6359 has attained finality by the dismissal of your SLP. That is what the learned single judge says.
Now, thereafter the subsequent 2-3 writ petition has been disposed of. Even after writ appeal number 6359 2018, again one writ today, again inquiry has been conducted, detailed inquiry has been conducted. That in the writ petition number 53029 of 2018, it has been disposed of. Again, thereafter, again, a challenge portion of the inquiry report in writ petition number 555 of 2020, it has been allowed and also set aside the allowed and granted with all other consequential.
That you cannot rely on because that is set aside in appeal and that was what was remanded. It is thereafter that this judgment has been rendered.
No, again, thereafter I'm questioning only portion of the inquiry report. Because, my lord,
Other portion.
53029 of 2018. While passing an order, the termination order has not been set aside. Either good or bad. Then thereafter, both the person are not challenged that order in the appeal. But whereas this Honorable Learned Single Judge, he exercised the rights of the Honorable Learned Single Judge, he passed that order deemed to be quashing of the termination order without elaborating the narrations or detailed explanations. It is a mechanical, technical. Even Court of Karnataka judgment also clearly stated that. So for a moment, I find it in the admitted in the written argument. Just for a moment.
My lord, one message has come from quota number 9.
Please.
Written argument for a moment.
You mean SL versus Karnakar?
Court of Karnataka.
You mean SL?
Yes.
ECIL?
Yes.
Yes. What do you want to rely on in SL?
Management other country Karnataka another reported in 1980 yes it's 1184. Yes, in all the cases where the inquiry officer report is not furnished to the delinquent apply in the disciplinary proceeding, the tribunal should cause the copy of the report to be furnished to the aggrieved employee if he has not already secured it before coming to the court or / tribunal and give employee opportunity to somehow this or other case was preserved because of non-supply of inquiry, non-supply of the report. If after hearing the parties, the court or tribunal comes to the conclusion that non-supply of the report would have made no difference to the ultimate findings and punishment given, the court tribunal should not interfere to the order of punishment. The court / tribunal should not mechanically set aside the order of punishment on the ground that the report was furnished as is regrettably being done at present. The court should avoid resorting to shortcut since it is the court or tribunal which will apply their judicial mind to question and give their reason for setting aside or not setting aside the order of punishment, and not any internal appeal or revision of that. There could be neither a breach of principle of natural justice nor denial of reasonable opportunity. It is only if the court or tribunal finds that the findings of the report would have made difference to the result in the case that it should set aside the order of punishment. Where after allowing the above, the procedure of the court or tribunal set aside the order of punishment, the proper relief that should be granted to is direct the reinstatement of the employee liberty to the authority, the management to proceed with the liberty by placing an employee under suspension and continuing the inquiry from the stage of furnishing him into the report. The question whether the employee would be entitled to the back wages and other benefit from the date of dismissal to the date of his reinstatement, if ultimately ordered, should invariably be left to be decided by the authority concerned according to law. After the termination of the proceeding, depending on the final outcome, if the employee succeeds the fresh inquiry and is directed to be reinstated, the authority should be at liberty to decide according to law how it will treat the period from the date of dismissal to till the date of reinstatement and what benefit. If any extent of benefit, he will be entitled. The reinstatement made as a result of setting aside the inquiry for failure to furnish the report should be treated as reinstatement for the purpose of holding the fresh inquiry from the stage of furnishing the report and no more, where such fresh inquiry is held. That will be the correct position in law. My lord, I set aside the termination order 8/3/2006. Till now, thereafter, 4 times order of termination has been set aside by the honorable. Till now, not been reinstated. They are not provided the substantial. Illegal inquiry has been conducted because no relations terminated. No even single paisa they are not given. They are not allowed to inside us. On what basis they conduct an inquiry? If I that order a question before the honorable court, also the court will say that what basis you are challenging before this court. What is the rule? Then where do I go, man? If I said if I succeeded the inquiry, also I can show to them also there is no law to provide the providing the back wages. They will say that. Where do I stand without law? Illegal inquiry. There is no provision of rule. And they cannot issue the termination order. The termination order, illegal termination order or any order, removal order can be issued only when the employee is in the service. When I am not in the service, on what basis they issued the termination order without provision of proof? Well, in the specific rule will be there, madam, in the company.
They have produced what they have produced and how they produce the rules. The rules cannot be, see, this is. Where is counsel, are you aware of the facts of the case?
Yeah.
How was MW1 examined?
MW1 examined.
Only one witness was
Yeah,
there.
only one
How was he examined?
There is evidence was recorded or any affidavit is filed in the leave of
Proceedings,
examination.
inquiry proceedings are there.
MW1 is offered for cross-examination. Where is MW1?
I submitted the statement of affidavit. The MW1 I submitted. Rejoinder. In that rejoinder, I submitted the copy of the notarization.
Was he actually examined? Was he made available for cross-examination?
He available for cross-examination only on document, not on documentary evidence, because the copies are not being served. Only history they have been served. Copies are not being served. Till now.
You assert that copies of the.
For 10 hours, copy are not been served. Even all the records are made it. Even inquiry officer also recorded.
My lord,
Which is why last time we asked for the reports of the inquiry to be produced. That is what they produced. No, it does not appear that copies have been served. Document exchange. Inquiring authority ought to operate within purview of document submissions adduced and produced.
History has been recorded.
Just a moment. Managers at liberty to produce as many documents. Liberty to produce as many documents. However, in the interest of inquiry, has provided ample time and opportunity from both parties before the inquiry authority cannot indulge in the exercise of document exchange. With the above observation, memos are disposed. Memo to summon 5 witnesses, author of documents. In the above 2 memos, DO is paid for more or less similar relief. As observed, it is on the management to prove their charges, so equally on the DO to prove his innocence as against the charges. Management and DO are equal at liberty to adduce evidence, cross-examine as many witnesses as needed. Inquiry officer cannot summon any witness in this regard at this stage. So MW1 is offered for cross-examination. DO submits it without documents relied upon. Where the documents given?
So, so if you see for the proceedings from the.
Yes.
35, the proceedings have been recorded and he has also signed. And the documents which they have relied is mentioned in the.
The management Karnataka, your page number 35, proceeding sheet.
Proceeding sheet. Then
Allegation.
Inquiry report.
Pursuant thereon, statement of allegations is served by letter dated 17/2. Pursuant to observation made by the Honorable High Court of Kerala and WP connected, undersigned has been appointed as, I have accepted the reference, fixing date of inquiry in the premises. As per track consignment, delivery of the above inquiry notice is confirmed. Where does it say that documents have been given?
He has received the notice.
It is not the notice, counsel. Have the copies of the documents that you mark in the inquiry been given to him?
The marking has been done subsequently.
How was it marked?
So where do you find the list of documents which were relied by the inquiry officer?
It's in the inquiry report, it is listed at the.
His show us where?
Page 25 onwards.
25?
That is 101, page number 101 in that latest.
Okay. 101. During the course of recording evidence of management witness, the following documents are identified and marked.
This is as part of the
Does
inquiry
he?
report.
Yes, it is part of the inquiry report. Has he been given copies? He sought for the copies of the inquiry report, the documents marked in the inquiry. He said without it, he cannot reply. Did you serve him copies? Did you at least permit him to see the copies and make notings from them? This is, yes, it has to be.
Here is, replies are there on page 69.
Counsel, what has happened, apparently happened in this case is because of the repeated litigations, a proper inquiry has not been conducted even now. It appears from the facts, which is why we call for the inquiry report. I mean, the documents of the inquiry. What is normally done? Normally, a charge sheet is first prepared. Along with the charge sheet, the statement of the statement of imputations, which provide how each charge comes about, is provided at the time of the charge sheet, along with the charge. Along with the charge sheet, also the documents, list of documents, list of witnesses, both are given. It is on the base, and then if he has to submit his reply. Before submitting his reply, if he wants any copy of the documents, or he'll at least be given an opportunity to see what documents there are. He can make notes from it. There are decisions which say that all copies of the copies are voluminous, all copies need not be given. Whatever it is that you're relying on should be made available to him. He must be permitted to see the documents. Then he submits his reply. Then it is decided whether to proceed with the inquiry or not. Here is a case where the first thing was termination. First thing, in 1993, terminated on the ground that, terminated on the ground that he is not suitable. That was found to be a stigma. Therefore, without conducting inquiry, it could not have been done, was the first finding. Then you again said that he is not suitable, he has to be sent out of service. Again challenged, set aside, directed that an inquiry has to be conducted. You say that you served a charge sheet in 2005. Then again, a writ petition is filed. It is found that charges are vague. That is taken in writ appeal. In writ appeal, it is held that no, charges are not vague. The material was there, and therefore he files a SLP. While that is pending, again the proceedings are taken. 17/2/2020, statement of allegations are given. In these proceedings, the learned single judge says statement of allegations were there. The charges were found to be not vague by the learned single judge, I mean, division bench. That SLP taken against that has been dismissed in the meanwhile. Therefore, we cannot say that the charges are vague. Therefore, proceed with the inquiry. The charges were there. Now, by this time, piecemeal, charges were there, statement of allegations were also there. Charges in 2005, statement of allegations in support of the charges in 2020, whatever. There are documents that you rely on. Ever in these proceedings, did you keep copy of those documents to him? That was something which should have been done in the first instance, not done. Anyway, so much water has flown under the bridge. Therefore, it is okay. You did not give at the relevant time. In these proceedings, before these proceedings were completed, did you give the documents? We are not on the merits of the matter at all. We are on the question of whether the proceedings have been properly completed as against it. You say you have lost confidence in it. You lost confidence several years ago.
Yeah.
Whatever. You don't want to re-engage him. Then for all these 4 times the inquiry was found not properly conducted. Not by him, but by you. Why don't you settle this matter by giving him at least the subsistence elements that he would have been entitled to? Don't take him back. Till now, after all these years, if you cannot hold a proper inquiry and find him guilty, an inquiry in accordance with your rules, you produce the rules.
No, actually, not gone into detail of the inquiry proceeding.
If you can show us that he has been given all the documents, or at least permitted to see.
This particular, because I didn't have time.
No, only this thing. If, as a matter of fact,
My lord's observation, I just tell my senior also. That you know. Meanwhile, I will also go through, because what I'm 100% in agreement with what you said.
this specifically was the reason we called for the inquiry records. To see whether at least this time, forget everything that he says. At least this time, have you conducted a proper inquiry? If in a proper inquiry, all the allegations that you've made against him are proved, then probably sometime a person is entitled to a proper inquiry. He may be the most criminal person on the face of the earth. Even such a person is entitled to a proper inquiry and a hearing and a fair procedure for the inquiry. That is all. Nothing else.
Just inform the police senior.
Can you not settle this in this manner? If you cannot, we'll pass on.
He said
just standing in for him.
He said he completed his argument even.
He has completed.
No, we want a reply on this.
And just he's in portal 9. Just check with him and come back.
No, the question is only this. Everything, forget all the other arguments.
We agree with us.
If it is not properly conducted, at least this time, then what is the point in sending it back repeatedly? He's lost almost his entire life.
My life has been ruined.
Now, how old you are? What is your age now?
62 minutes. Still my sons are wandering by giving the newspaper and is studying. Both sons are there, they are assertion. I don't have learned shelter. My mother is multiple stroke, she is suffering. My father is 95 years, I don't have any shelter.
Just
Any question of reinstatement doesn't arise since he
Question of
already 62
reinstatement
years.
does not arise. So at least,
Whatever financial.
if as a
benefit
matter
you
of
can
fact, this round of inquiry is not properly conducted, stop it here.
62 years and Again, further conducting inquiry.
It is, if it were a case where he was conducting all these cases and losing all of them, then that is another matter. Here is a case where 4 times this court has found that the inquiry is not properly conducted. Even the last finding is that the inquiry has to be conducted. Now, at least at this stage, should the mighty state not stop the proceedings? You are the state under Article 12. Should there not be an end to this? At least at this distance of time. If, as a matter of fact, this is correct and it was not procedural irregularity, this finding of guilt would have been supported by documents. And that would have come across at least once in all these years, a clear finding of guilt would have come across at least once in all these. A sustainable finding of it has not happened in this. Let's stop this.
Just check and come back to itself or
he has to come again.
Yeah.
You are here in Bangalore itself.
My lord, I'm going to my native place.
Where is your native?
From here to there, more than
Unigal.
120 kilometers will be there. I look after agriculture. My father is admitted, mother is admitted in multiple sclerosis suffering. Unani hospital is there. Since 10 years is suffering.
No, it is only for this. Please.
I don't tell you. I'm starving.
Please join online on the next date of posting, because even if we wait, we are at 4:40 now.
Both side is completed. Kindly reserve. Nothing will be there. Because everything is clear.
Tell if it is.
Because they are going to drag on.
My lord, as you suggested, matter will.
If, as a matter of fact, these facts are correct, then we have no doubt on the aspect.
So I am not fully thorough with the facts of the case.
If we pass an order without considering this, then again they'll probably file a review and you will again have to come.
Yes, I'm struggling for the justice till my death. Yeah, because my life has been good. Because my son also somewhere here and there is somehow earning. So that I'm making my family. But till now, because I really postulated, but I have full confidence about the judiciary. Till my death, I'm struggling for the justice. Kindly reserve for pronouncement of the my argument is over. Whatever the order I'll be receiving by now.
If you want anything further is to be stated, please make it as a written argument.
If I check with my colleagues here.
Yes. Do you want a further posting on this? Do you want a further posting or will you just file your written arguments?
Not be required. May not be required.
Yes. Reserve. Regulations are of the if as a matter of fact, we have not given the then this is the resolution. Instead of absolutely.
With my lord's kind leave, my lord. My lord, this was a matter which was disposed of by Justice Dinesh Kumar, my lord. The registry has designated a special bench with my lords and Justice T.G. Shivshankar Gowda. I had filed these applications actually in July, my lords. I've moved it a few times. I've moved it once before my lord.
What is the matter about?
The RERA appeal, my lords. RERA appeal.
RERA appeal.
RERA appeal, my lords, where it was.
As of the number of separate judgments, I mean, separate combinations is not enough. We had 3 combinations.